appeal in the matter of South and Santander Cards UK Limited and appeal in the matter of Harrop and Skipton Building Society.
Yeah. Yes.
My lords, my lady, as a matter of housekeeping, I believe that Mr. Butters has handed up a copy of the first instance decision in Smith and Law Bank of Scotland.
Oh yeah.
Okay. Yesterday I provided the court with an introduction on as the documents that sit below my client's defence and their appeal.
Yeah.
Today I intend to cover three key, more substantive points. Firstly, the question of consideration, as to which broadly two further issues or sub-issues arise, the effect of DISP, and secondly, the effect of the redress letter. The second key topic I intend to cover is the question of construction, an aspect which I intend to give light touch to, given the time that was spent looking at the documents yesterday. And thirdly, the question of reopening the settlement and the effect of the compromise on any assessment under Section 140A of the Consumer Credit Act 1974. Turning first then to consideration, my learned friend Mr. Wheeler said that payment would ordinarily and straightforwardly, some might say, be regarded as good consideration for the settlement of a claim, because payment of money is good consideration. In so submitting, he emphasised the point that it is the payment of the settlement sum that is the consideration. That submission, though obvious when put like that, was necessitated by the submissions of both counsel for both appellants, that because there was a prior obligation, they say, to make an offer of settlement, the offer itself was not good consideration. But that, of course, makes a fundamental mistake, that it is not the offer that is the consideration. Looked at properly, we submit, that is no different to any ordinary contract. It's a matter of basic contract law that where an offer is made, it is not binding until it is accepted. Until that point of acceptance, there is no obligation to pay, and certainly no obligation to offer a specific amount. If that offer is then accepted as a matter of basic contract law, and payment is made in accordance with that acceptance, no one...
I'm sure sorry to stop you so soon, or interrupt you so soon. I'm sure you're probably right about that, but I'm just niggling. If you have an offer to pay and an acceptance of the offer, you then have a complete agreement on which you could sue. So, isn't at that stage the offer to pay good consideration for the agreement?
The consideration for the agreement would be the payment, and the right to sue arises from the breach of your obligation to make that payment.
I'll go back to page 1 of Chitty. Thank you. That's okay. That's fine. I'm sure you're right.
Put another way, if payment is made in accordance with that acceptance, no one would be able to turn around before the court and say that because the paying party was under an obligation to pay once their offer had been accepted, there was no consideration for the payment. And we say the payment of the money is the consideration. The only prior obligation it can discharge is the obligation to pay that sum. Which takes us back to paragraph 18 onwards of my skeleton argument, and another elementary principle, and the rule in Folks and Beer, which the claimants seek to bring themselves within by saying, nonetheless, there was another relevant obligation in place. And we say, quite simply, they are wrong. The learned His Honour Judge Owen on appeal apply the established legal principles and the fact that there is where there is a pre-existing legal obligation to pay a sum, a promise to pay that sum does not afford any consideration to support a contract. But that is a principle which, as Mr. Wheeler articulated, does not assist either of the appellants in this case. They are wrong to say that because, in Mrs. Self's case, Santander was obliged by DISP Rule 1.4.1 to make an offer once and only once Santander had determined that it was appropriate to do so. Their case then falls within the principle in Folks and Beer. 2 points arise. The first is the argument that Santander had done, and I quote, nothing other than what it should have done. That argument confuses the obligation alleged in the complaint itself to have been breached, that is the obligation under section 140A of the Consumer Credit Act, and the obligation in DISP 1.4.1 taken together with the unenforceable rules in DISP Appendix 3. The obligation said to have been breached, section 100, and in respect of which the complaint is made, the unfair relationship said to arise under section 140A because of the failure to disclose commission, is itself unconnected with the obligation said to under DISP 1.4.1, which is said to preclude the existence of consideration for the settlement of the complaint. More obviously, there is then a distinction between DISP Rule 1.4.1 itself and DISP Appendix 3, and it is only Rule 1.4.1 with a capital R that is enforceable in the sense it can be sued upon. And it can only be sued on not directly as breach. It itself doesn't give rise to a cause of action within the provision. One relies on section 138D of FSMA 2000 and says that breach of Rule 1.4.1 is actionable and then has to go on and prove one's loss.
Yeah.
The law, of course, is concerned only with legal duties. And the claimant's assertion that there were obligations under DISP Appendix 3 misses the point. The court is concerned with legally enforceable obligations. Complaints are frequently made about obligations held in day-to-day life, moral obligations and so forth. That isn't the issue before the court. What they must demonstrate is a prior legal obligation to do that which they did by their offer, and they cannot do so. It is much the same as the fact that the principles in force at the time were not enforceable directly in and of themselves, and those are the principles of business which firms are required to comply with, including the one I referred to yesterday, to treat customers fairly. Those were not actionable in and of themselves at the time, and that was expressly the case under section 138D. So again, there was an obligation, but it was not an obligation enforceable by this claimant before the courts. So too, is there a distinction between DISP itself and section 140A. DISP didn't, of course, require the making of any payment unless and until an offer was accepted. We couldn't therefore be in the Newton-Moore situation of a cheque simply being dispatched by Santander, professing itself to be made pursuant to DISP and in settlement. But section 140A is even more remote from that. There is nothing in section 140A which requires the making of an offer, still less a payment. And in that respect, the learned judge on first appeal was correct in his conclusions at page 102 of the core bundle, paragraph 22, and subsequently at page 105, paragraph 33, where he upheld the reasoning of Her Honour Judge Belcher in Taylor and GE Money, affirming that there was no obligation, whether under those rules or otherwise, to make payment of any sum to the appellant unless and until an offer was accepted, and setting out that accordingly there was a benefit in that no matter how wide the waiver and whether it merely offered the sum suggested as a default under Dispat 3 or some other sum, she got for the first time an entitlement to pay a sum of money, and that goes on to page 103 of the bundle.
103.
Is the yes, that it's
Paragraph 22 of the judgment.
Yeah.
It's reliance on the decision of Judge Belcher, isn't it?
and that of course makes the established point that the payment, that on its face, the benefit that was there was a benefit from the settlement agreement. For the first time, Mrs. Self achieved the right to obtain payment of a specific sum, a quantified liquidated sum, by way of contract, which could be recovered by a straightforward breach of contract or debt claim through the small claims courts with nothing more. There's indisputably a clear consideration for the avoidance of all the delay, costs and risks inherent in litigation versus the obtaining of an immediate right to payment. Contrast, of course, with that, a claim under section 138D, where the breach would have had to have been established and loss would have had to have been quantified. Which brings me to the second point under this subheading, the need for an undisputed liquidated sum. Because of course the claimants seek to bring their, and the appellants seek to bring their case within Folkes and Beer by saying practical benefit is of no relevance. But those situations are concerned with claims for undisputed liquidated sums. This was neither. Even if there was, we say first and foremost, there cannot have been an obligation to make a payment at the point the offer was made. But even if there was already such an obligation, the appellants haven't been able to point to a single authority that is anything other than a conventional application of the rule in Folkes and Beer. That
If
is,
you think about it, if you make, your client makes the offer. If the offer isn't accepted, I mean, if Mrs. Self had said no, I'm not interested in that, she could have gone off to the county, off to the Ombudsman or to the county court, but she wouldn't have had an argument available to her to say, well, they're in breach of contract because they offered me money.
precisely.
The short answer to that would be if you wanted the money, you should have accepted the offer.
My lord has the point precisely, yes.
Yeah. Okay.
And the making of an offer of less than the other party is seeking is good consideration where the claim is unliquidated, and that's well established, and it's the authority is referred to in my skeleton argument, but it's an extract or citation of Simmentov, which can be found at page 539 of the authorities bundle.
Should we have a look at that?
Apologies,
So page 539.
I think I've got, there's a typo in my notes, and if I just might have a moment.
Just going back very slightly, in the meantime, this night, it's also analogous that if you can't go to the Ombudsman and say, I didn't accept the amount that was due, but now I would like to, and then I would like you to deal with the matter as the icing on top. You either, once you don't accept the offer, you don't accept the offer because the whole issue remains undetermined, and that altogether goes to the Ombudsman.
Yes.
But if you were in a situation in which you could say, I've not accepted the offer, but they're still obliged to pay me, then there would be a situation where when you went to the Ombudsman, you'd have to say, but actually they're still obliged to pay me £800 because they offered it. And the Ombudsman would be dealing with the stratum above that. And that is not how the system works.
Exactly, yes, my lady. The reference, apologies, was 529 of the bundle.
I apologise for that.
No.
529.
And this is CFL Finance and Gertner, 2001 EWCA Civ 228. And this is simply a statement of paragraph 37 of the judgment, paragraph E of the page.
It's a citation from Sim, I'm told, isn't it?
Yes.
Could you give the reference again?
Page,
Page 29.
of page 529 of the authorities bundle.
Thank you.
Should we just read that to ourselves?
And my lords, my lady, it becomes apparent from this that oral is clearly distinguishable. The court's been taken to it on a number of occasions. I don't seek to cover the judgment substantively again, but it is clear that in that case there was a defined sum payable by statute. There was an obligation to pay as a start point. In this case, there was no such thing. The obligation is merely under DISP to do what is appropriate, which may be payment, or it may not be payment. It may be a payment of 50%, or it may not. That's entirely different to the defence available under the statutory regime in orale. Orale is simply a proper application of the rule that the relevant obligation cast upon the defendant by law must be the obligation to pay an undisputed liquidated sum of money. Even under DISP Appendix 3, in this case, there was never a figure which could be pointed to.
Well, that's the point, isn't it? I mean, even if you look at it in terms of as an obligation an obligation to provide redress pursuant to Appendix 3, that doesn't get you to a liquidated figure.
Quite, yes.
Because it all depends on you can't simply say, well, it's the 50%, because the DISP 3 itself makes clear that may not be, in a given case, that may not be the appropriate figure. There may be other factors to be taken into account.
Indeed, and both under DISPAP 3 and under the substance of the complaint itself, which wasn't a complaint that Santander hadn't complied with this, it was a complaint under Section 140A.
Yeah.
There wasn't even an automatic right to a financial remedy.
No.
And in those circumstances, it is simply incomprehensible to say that there was no consideration, because by offering to pay a financial sum of money that hadn't been, to which there was no prior obligation either in money or in quantum, there was no consideration.
Yeah.
Which takes me then to my second point under the heading of consideration, which is that of the construction of the redress letter itself and the effect. And this is covered at paragraph 40 onwards of my skeleton argument. And this is in effect their case that none of this matters if they're wrong, because in any event, by the redress letter, we admitted liability. Now, the redress letter, for ease of reference, is found in the supplementary bundle. And it is found at page 32 onwards.
32,
Now we say the fact of an omission simply isn't the case on the clear facts of this letter. As was said by the learned first appeal at a judge, at paragraph 10 of the judgment, it's an exercise for the court in construction. There isn't a great deal between the parties in terms of how that exercise is to be undertaken. It's agreed that the court can have regard to what was known by the parties at the time of the contract. There's a distinction, of course, between
Thank you.
There's a distinction, of course, between negotiations and the facts known by the parties. And we're, of course, concerned not to make impermissible reference to antecedent negotiations. But in construing the agreement that was reached by the parties, at the very least, the CAF is the relevant document, but it is said by Santander that it is the CAF taken together with the redress letter. They were created at the same time, sent at the same time, and both cross-reference one another. Now, within...
Look, you can't really test it this way. This letter, it contains an offer to pay £800, whatever it is, £830.84, which they could accept or which Mrs. Self could either accept or not. But if she'd not accepted it, she couldn't have gone to the county court and said, give me £830 anyway, because they've admitted that much is due.
Quite.
Because it's an offer which is written in water until it's accepted.
Indeed, yes, my lord.
You
And
need
that-
something that more than that. You need to say, we admit that an irreducible minimum of £830 is due to you. If they'd said that, well, of course, you'd be in different territory.
Yes, what is pointed to is a single word on page 33 of the bundle, the word in order to calculate the amount of redress due to you.
Yes.
So in order to succeed on their admission claim, they have to say that the redress letter is part of the agreement. And the word due is not there set out as stating an obligation. It is in the context of page 32 itself, which is makes clear some aspects of the complaint haven't been upheld. They've considered whether there was an unfair relationship, and we'd like to offer you £830.84 in full and final settlement.
Mm-hmm.
And then the word due is under the bold heading, details of our offer. And then, at the bottom of page 33, what do you need to do? And also in bold text, if you want to accept our offer, please complete the CAF. And then in the final sentence on that page, if you accept this offer, it will be.
Yep.
It could not be clearer in its terms that it is the making of an offer. There is no admission of an unfair relationship. We simply declined to rebut the presumption and made no mention of it. She herself hadn't contended that she was entitled to the settlement sum, such that there could have been an acceptance by Santander of its obligation to pay it. On the contrary, the very essence of her complaint was that she wanted all of the commission payments refunded, and this offered her half of them. And Mr. Wheeler took the court to the absurdity that would follow if, in entering into negotiations and in the making of offers to settle claims, parties couldn't actually make an offer for fear that it would be construed as an admission.
But if it weren't for this would be completely straightforward.
Yes.
It's an offer to settle. It's not what she wants, because she wants it all, and you're offering half of it. So somehow the construction for which the appellants contend has to incorporate DISP in some way as part of the offer, or as at least as part of the background information known to all parties, so as to affect the meaning of the offer. But if they can't get it in like that, this is completely straightforward.
Indeed, and this letter makes no reference in terms to DISP, and the complaint letter itself made no reference to DISP. And as Mr. Wheeler rightly submitted, and whose submissions I adopt, one cannot self-impose or crystallise relief which a claimant says they are entitled to by a unilateral action on the defendant's own part. And of course, this is one step more remote than that, because an offer of half of what was sought cannot be said to be crystallising relief that was sought when the relief that was sought was repayment of the whole. There is nothing beyond the fact of settlement that could convert the claim into one for a liquidated sum. And to say that a defendant, by making an offer to resolve a Section 140A complaint, is thereby crystallising the relief to which a claimant is entitled under that section, would be to tie the hands of the court.
Yeah.
And would fall foul of the very provision of Section 173(1) to which Mr. Butters himself relies. And of course, we've objected to reliance on Section 173 because although it is raised in the reply, it wasn't argued at first instance and it wasn't argued on appeal, and indeed the bundle of further authorities was put before this court without prior agreement. But even if one has regard to it, it takes them nowhere. And in respect of the consideration argument they raise, it undermines it. And this takes us then to the distinction with Newton Moore, upon which both appellants rely. It's trite law that there's no settlement without agreement. And in that case, we are exactly on point with Lord Justice Everley and his decision in that case, where he was clear that there was no agreement between the parties. This is a fundamentally different case. It isn't a case where a cheque was tendered immediately rather than as an offer. And it isn't a case where the terms upon which it was tendered were expressly rejected. On the contrary, it was a cheque tendered after the making of an offer which was expressly accepted. The appellants simply cannot bring themselves within the scope of the very narrow rule in Folks and Beer. And indeed, Newton Moore emphasises the importance of the terms, and the terms on which the parties have reached their compromise, which is the very reason why first instance decisions of district judges, like that in Smith, where it's a one-line decision, simply adopting a skeleton argument that we don't have before the court, isn't decisive. One doesn't know the full terms and the full circumstances of that agreement, and one doesn't know the reasons why the particular litigant in that case didn't pursue a compromise claim and chose instead to focus on limitation on appeal. In contrast, if one is going to start banding around references to decisions of the lower courts, there are a wealth of decisions relying upon Taylor, cited for way of reference in my skeleton argument, which determine cases on the terms that are before the courts today. Fundamentally, therefore, if there was not an inconclusion on this head, if there was not a binding settlement, i.e. a contract, then it removes the very uncertainty that we saw in the policy statement yesterday was the purpose of the DISP rules. Which takes me then to my second of my three proposed greater topics, that of construction. And subject, of course, to any particular points with which I can assist the court, I intend to take it relatively briefly. We looked at the letters yesterday, we've looked at them again just now. But the salient facts are that Mrs. Self sought redress by way of compensation for all of her commission payments. The redress letter offered half. It was, but therefore, by very definition, an offer, and she signed the CAF saying it was an offer, and as such, it's one of the clearest imaginable disputes. And for the appellants to say there was no dispute simply does not accord with the reality of the facts.
There's a dispute unless and until someone says, I'm not pursuing it any further, or caves in.
Indeed, and there was a fundamental dispute as to what she wanted. She wanted it all, we offered a fraction, she accepted. And of course, orale, another extempore judgment, is obiter on the question of construction, but it still doesn't assist her when one looks at the words of the agreement itself. In orale, one saw at, page 63 of the bundle, the authorities bundle, second column, that the offer was expressly made pursuant to the Dubai ordinance in question. And at the bottom of the following page, page 64, second column, last paragraph, is Article 4.3 of the ordinance, which says the provisions will expressly, without prejudice to any right which any other law, contract, or service agreement or decision gives to the workman. We didn't identify this payment was made under any statutory obligations because there wasn't one. and there was no express reservation of rights. On the contrary, there was a clear waiver of them.
Yeah.
And the court asked Mr. Wheeler how their offer was to be characterised. In our case, we say it doesn't matter whether the redress letter is used or not. We say that the court should construe the redress letter as being part of the offer and as such waiving the entirety of the PPI claims. But we say even if the court doesn't need to resolve that, and it doesn't need to go that far, because the terms of the CAF are so clear in terms of the resolution of, and to take the court back to it, that is in the supplementary bundle, and it is at the signed versions at page 41 of the bundle, and it is expressly settlement of my non-disclosure of commission complaint, and then refers to further issues on the same or similar terms. Well, that is what is being claimed in the particulars of claim. So even if one restricts it to the CAF itself, the construction question does not take the claimant, Mrs. Self, any further.
Well, unless it forms part of the necessary reasoning to support the conclusion that the Section 140A claim has been settled by this document. Anything we say about any wider claim, in your case, would be overturned.
Yes. Quite
And
right.
we may be unenthusiastic about embarking on overturn things that, but it may arise in the other case.
Indeed, yes. And that is simply because fundamentally these are contracts. So there are differences in the documents between
Well, there are differences
two
in what
entities.
was claimed, but even, I think I'm right, even in Harrop, the claim that's now brought is simply a Section 148 claim.
I believe Harrop is a wider claim, and that's one of the points of distinction between the
Okay, well,
parties.
we'll check that. It was the original claim, the original letter of claim, definitely went
Ah,
wide.
yes, yes.
But the
yes.
proceedings that we are dealing with an appeal on simply proceed on Section 140.
That's right,
So
yes.
in that respect, again, it's going to be overturned to start issuing great statements about the width of the settlement.
Indeed, but the court may wish to do so in light of the submissions made by Mr. Butters that the CAF, in fact, if it's to be construed as waiving anything, on his second alternative proposition is waiving a right under Section 138D, which we say absolutely does not make sense to say that a waiver which makes no reference to Section 138D is waiving such a complaint when that any possible complaint under Section 138D was not referenced in the complaint letter and could not have been so referenced because the obligations under DIS 1.4.1 didn't arise until the complaint letter was received. But to say, although that claim is being waived, a claim to Section 140A on the same cause of action, on the same facts, to which reference was expressly made in the complaint letter and the redress letter, isn't waived. And it's further said that it's not possible to make it full and final settlement. But a suggestion that one couldn't make an offer under DIS in full and final settlement would cause the very confusion and uncertainty that DIS Appendix 3 expressly sought to resolve. And there would be extreme consequences if this were only capable of being a part payment.
Well, the past may have been sold on that by acceptance that DIS plus 10% would be settlement. Do you remember I asked?
This is where we got into kicking donkeys, as this I believe is where we got into kicking donkeys, my lord.
We might have gotten to donkeys. The donkeys slightly left me standing, but But once you accept, as I think they have to, the other side have to, that just about 3 plus 10% is a settleable offer, or is an offer that's capable of leading to a settlement in full and final satisfaction. It logically follows that anything other than the specific calculation, which in fact you both did, both institutions did in this case, it is capable of giving rise to a settleable offer.
Indeed, and the only way they can get round that is by satisfying the court that there was a prior obligation to
Yeah,
pay that
yeah.
sum of money, which they cannot do. And
It's getting a bit narrow if we get to that point.
and one can look at it another way. The court was taken yesterday to the 2014 decision in Clark on the effect of, and the res judicata effect of a decision made by the Financial Ombudsman Service and accepted by a consumer. And we say it would be inconsistent, to say the least, to have a complaints regime that, taken to its end point, a complaint to the Ombudsman, is full and final settlement and is binding on the parties, but yet not permit regulated entities to offer full and final settlement in an earlier stage of that process. The parity of reasoning makes it all the more apparent the illogical conclusion that would lead to. The Ombudsman Service is itself an alternative dispute resolution scheme, and to say that parties cannot resolve a matter in a binding manner at an earlier stage of an ADR process, we say is nonsensical.
You have to recalibrate everything, don't you? Because you have to say, actually, any sum offered is a prepayment. The Ombudsman, as I mentioned before, is actually only dealing with the second layer above that prepayment. And none of that is how the system works.
Yes, and to say that if your claim is determined by the Ombudsman, it's final and binding and you can't take it to the court, but that at a prior stage of that Ombudsman process, you can't settle it in a binding way, is absurd. And the consequences, we say, are obvious. Firms would simply cease making acceptable offers to consumers if they couldn't,
The Ombudsman.
and would simply say, if we can't achieve a final and binding settlement and we're precluded from doing so because it's an unacceptable gloss, then everything has to go to the Ombudsman, where at least it is binding.
Or the other side of that coin is they make offers which are not full and final, and the everything, nevertheless, goes to the Ombudsman, and the Ombudsman system is completely overrun, which was not intended either.
No, and it is, indeed, it is already somewhat overwhelmed, and a finding such as that contended for would mean there was no benefit to early dispute resolution within an alternative dispute resolution system. Which brings me then, unless I can assist further on that point, to the question of Section 140A itself and reopening the compromise. If I could begin, please, by taking the court to the decision in Smith, which is within the authorities bundle, and page 725 thereof.
$725.
725, paragraph 40.
Yep.
And this is the burden of proof point.
Yeah.
And on the facts, it may not take the court any further if it's satisfied there isn't any unfairness in any event. But it does, we submit, merit consideration, particularly in light of the pleading of the claim itself. And it said there in describing the burden, this does not, however, mean that the claimant is absolved from pleading particulars of claim which identify concisely the facts on which the claimant relies. And I touched upon this in my opening yesterday when I took the court to the unfair relationship pleading in the particulars of claim. And if I could ask the court to turn back to the core bundle, page 173.
I'm really looking at
173,
Yeah.
and that's the pleading of the unfair relationship. And one will see there that what is pleaded is purely unfairness arising out of
Commission.
prior non-disclosure of commission. And when one progresses through to page 176, the bottom thereof, paragraph 20 and 21, which goes on to page 177, this is the only point at which the compromise is referred to. And at paragraph 21, it is phrased as such: the claimant avers that the partial refund has not settled the unfairness associated with the commission and therefore claims full repayment. But no particulars are given of why that is the case. And, as Mr. Wheeler took the court to yesterday, that's also the wrong approach.
Well, how would you plead it? It's pretty blooming obvious what they're saying. What do they actually have to plead in addition to paragraph 21?
Well, the
You
Supreme
could say,
Court
I
in
suppose, the actual settlement is characterised by unfairness. You could say that. But that's not, what else should they say?
well, first and foremost, they're taking matters in the wrong order. As the Supreme Court in Smith at paragraph 20 onwards made clear, one assesses the question of unfairness of a relationship. In a case like this, where the relationship had ended by the time it reached the court, one assesses it as at the date of the end of the relationship, which in this case is after it's been reopened by virtue of the settlement agreement. So the end of the new end of the relationship is at the point payment under the settlement agreement is made and completed, and one assesses fairness at that point. And the court is clear that, as set out at page 20 to 21 of my skeleton argument, it's irrelevant that that an agreement was unfair before that time, because one is looking at the matters in the round at the end of the agreement. So it's not a question of whether it was unfair before and something has been done that has remedied it. It is a question of the state of that relationship at that moment in time. So if they wish to plead that it remains unfair at the end, then they need to identify why, notwithstanding the making of a settlement agreement that they accepted and which was made pursuant to an offer made by a regulated entity using as a calculation method the scheme set down by the regulator, made to the customer whilst represented by a claims management company, was not fair.
But they were just, in a Rolls-Royce existence, I can see how you could make these particulars of claim 5 times as long for no particular benefit. All I'm picking you up on paragraph 21 is what more does actually need to be said, because what seems to be perfectly clear that their case as emerging from the particulars of claim is that notwithstanding the fact you've made a partial payment, which we don't accept as a full and final settlement, the relationship remains unfair, full stop. And that's more or less what 21 says.
It's what should have been pleaded are the very submissions that were made at first instance and on first appeal and have been made again before the court. That there was no for example, there was that the Santander didn't disclose the amount of commission that it received, that the settlement wasn't fair because no legal advice was obtained. The matters that they say entitle the court to do that, which courts are notoriously slow to do, namely go behind the settlement. Because on its face,
Thank you.
where the parties have settled a dispute, i.e. given an outward accord that they have no further issues, no further complaints, that they are satisfied, that matters have been put right to their acceptance and to their satisfaction. If they wish to say that notwithstanding that, the relationship is still unfair, then they need to say why that outward accord is tainted in some way.
Was this case, well, I mean, most consumer credit, certainly in my experience when I was at the bar, you get a problem arising out of the Consumer Credit Act, hundreds of disparate decisions in the county court, then someone says, come on, we've got to get this sorted. Were either of these cases actually set up from the outset to be test cases or
No.
lead cases?
No.
So, fine.
We've just got hundreds of cases milling around in the county courts, which are all not dissimilar facts, but may not be identical facts.
Presently, I'm not sure they're doing much milling. I believe they're fairly stationary, but yes.
Yeah, I mean, there are a lot of them,
Yes.
we're told. I don't know how.
Yeah, okay. But anyway, you've answered my question on 21, at the least.
But I mean, their case really, as I understand it, is that because we wouldn't have taken out the policy if you told us how much commission you were making out of it. We're entitled to the only thing that will, as it were, resolve the unfairness is repayment of everything.
Yes.
The whole repayment of the whole commission.
Yes. So
the whole premium rather plus interest.
So essentially, their complaint as to unfairness is we struck a deal, we've changed our minds.
Yes.
And that is the nub of it, and that is why there would be such serious problems were that to be taken to be what is permitted by the process and by clear compromise such as this. Because we say one has to, if they are to challenge the conclusion, having regard to the existence of the settlement agreement, must be that that settlement agreement rendered.
But if it doesn't cure the unfairness, then it has to be on the basis that only full payment will cure the unfairness. So as you say,
yes,
it's effectively saying, well, we may have accepted this money whenever it was in February 2021, but we now decided we want more.
yes, and that would go contrary to the policy statement and the rationale that lay behind it. But also we say they shouldn't fundamentally be able to go, if they were to do that, they would be achieving by the back door the ability to go behind a binding settlement agreement.
Mm-hmm.
Of course the court has jurisdiction to consider a Section 140A claim. That's the very reason why Section 173 doesn't get the claimants anywhere on this. But in order to do more, the court isn't looking at facts predating. The court, in order to succeed, they have to show good reason why the court needs to go behind the settlement agreement. The court won't ordinarily do that absent something inherently wrong with the settlement agreement. For example, bad faith, fraud, undue influence. And it's for that reason that we see references in Hollyoake and in Smith to the use of parties being represented by legal advice. It's not the giving of legal advice per se, it's the involvement of a third party acting for the benefit of those who are party to the agreement. And it would be a truly extraordinary position if, as Mr. Mallin submitted, that claims management companies, who are themselves regulated entities, weren't necessarily acting in the interest of their clients because they were seeking to resolve these as quickly as possible, and that somehow detracted from the performance of their duty to their client. That would be an extraordinary basis for going behind settlement agreements, to say that a party representing its customers was not protecting them. It's not a question of whether there was legal advice, it's a question of whether there was any protection against one party, a potentially stronger party, taking unfair advantage. And again, Mr. Mallin said, well, how would a claimant know what they had settled? Well, simply by looking at the complaint letter they made. In Mrs. Self's case, she complained about breach of ICOB, and she complained again about unfair commission. But how did she know what she was giving up? Well, actually, it really wasn't difficult. She wanted it all. We offered half, so she was giving up her claim to the other half. Nothing more, nothing less is the issue here. And so the court has to have cogent reasons to go behind that settlement agreement.
But
It's sort of
getting the money now, getting the money now.
Apologies.
But getting the money now.
Yes, and having had the benefit of that money and then coming back for more when the parties themselves had agreed on an otherwise untaintable document that the payment of £830 odd had resolved and satisfied the complaint and satisfied the unfairness.
You've got also, you can rely on in the letter of redress at page 39, there's a section about how have you calculated my redress.
Yes.
In the FAQs. So even if she was unclear to the form, you can submit, it may not be accepted. That gives a clear indication of what you've done.
And at paragraph 21, instead of giving the reasons why one should go behind the settlement, you've suggested some of them tonight. What in effect is being said, it seems to me, is it's not possible to settle a claim like this, and so whatever it says is irrelevant because it's not possible. This is a part payment.
I think that's the logic of the logical conclusion of the argument is that nothing less than 100% will do.
Indeed, and that we say is one of the significant policy reasons why the appeals should be refused. But we say it is a policy reason that is substantiated by the law as it stands. And indeed, one only has to look at some of the arguments raised by the appellants in turn to see why this is. For example, they say one of the complaints is that the redress letter didn't set out the actual level of commission. But that cannot be decisive, because in any ordinary settlement agreement, the court is not concerned with whether both parties have fully disclosed everything relevant to their claim. Indeed, it's generally the reason why parties do settle agreements, that they have something in their files they don't want the other party to know about. But absent bad faith, fraud, undue influence, and those established grounds, that's fine. There's no duty of good faith in
I have
it.
some difficulty with that because you're operating in the milieu of section 148,
We are.
which imposes an obligation on a regulated entity not to act unfairly. So different considerations apply from a straight arm's length, non-regulated settlement, where you're absolutely right, they may settle precisely because they don't want to settle.
To an extent, yes, but we are also operating in a sphere where the FCA has had undertaken extensive consultation and set down by DIS App 3 rules by which firms were required to operate, in colloquial terms, in breach of which would be evidence of non-compliance with DIS 1.4.1, and nowhere in it was it said either you must disclose the full amount of commission to your customer, and nowhere was it said you cannot settle in full and final resolution. there is nothing set out by the claimant, by Mrs. Self, that would warrant the court stepping behind this agreement and undermining the finality of settlements. If I might just have a moment.
Yes.
My lords, my lady,
Lovely.
unless
Thank you
there's
very
anything
much.
I can
No,
assist
thank
the
you very
court
much
with.
for tonight. Thank you. Right, Mr. Mallon.
It's over to me. May it please the court. The thing I want to do first, and most significantly I think, is strip everything back to the relevant legal obligations. Because I think once you resolve that, once you see what happens at each stage, and what obligations are engaged, much of the rest of this kind of falls into place. There are different little boxes it can fall into, but if you get those obligations right, I think everything then becomes comprehensible and relatively straightforward. So I really want to focus on that. Of course, I've heard the questions from the bench, and I know which way the mood is, shall we say, at the moment. I know no judgments have been made, so I know I've got to deal with that. But I do have a concern from those questions and the submissions that have been made that at the moment the sense of where these obligations lie and the significance of them is going down a wrong path. So I'd like just to try and steer that in the direction that I say it should go. Now, excuse me. The simple starting point proposition from a learned friend's case is that the only obligation that arose in this case was a contractual obligation, and that only arose once payment had been made. I'm not going to dwell too long on that, but I have to say that payment being made must simply be wrong for the reasons that the bench mentioned at the time. That's after all the promises have been made, but I'm not going to dwell too much on that because I think their case can be put better than that, and I want to address it as it could be put, not in that sense. In other words, you could see a situation where there's an exchange of relevant promises here. The question I'm going to address is, when you've identified those relevant promises, is there consideration moving from the promisee in respect of the important one? So I'm not going to try and major on the fact that actually the idea that payment is the consideration simply falls flat on its face. But if I'm wrong about that, my other arguments go to it anyway. So I think where we can sensibly start, because I think court has a pretty good picture of the underlying framework, so I'll go back through that in detail. I think we can track the obligations quite well in the redress letter itself, the development, if you like, of those obligations. So that's at page 246, core bundle. And the relevant part, as the court is now aware, begins at the bottom of 247. The I have also, but really starts substantively at the top of 248. Oh, sorry, I said core bundle. I've just been corrected.
Meant supplementary.
Forgive me. Sorry.
You meant supplementary. I decided 247.
Then on to 248, please.
Yeah.
So, taking this stage by stage. First paragraph. Financial Conduct Authorities established that redress is due. Now, I'm not putting overemphasis on that now. The suggestion has been that people have extracted individual words here and tried to really build a case of obligation on words out of context. I don't need to overemphasize the word due in isolation for the moment. Due to non-disclosure of commission, and the result is an unfair relationship. And this resulted, in an unfair relationship. If the commission at the point of sale was or had the potential to be more than 50% of premiums, over the period the MPPI policy was live, we are required to presume this created an unfair relationship. Start there. This is the language of obligation on a regulated entity. We are not talking about contractual decisions. And that's one of the places that, with respect, I think my learned friends both go wrong, because they address it as though Skipton had some choice in the matter. And my learned friend was now quite close towards the end of her submission, said, well, what would be the upshot of this? These regulated entities wouldn't make offers. Yet here they are absolutely required to make offers as long as the criteria are satisfied. So that simply can't be wrong. And And the role of imposed obligation versus freedom of choice is of critical importance in this case. And we see how it develops. So, second paragraph, having assessed the MPPI products held, we have found there was a non-disclosure of commission, and this was above, or had the potential to be above 50% of premiums at the point of sale. Pause there before the correct conclusion is drawn. What is being said is, we were required to do something, and we have done it. The consequence of that something is an outcome. It is an obligation. Now, there were various questions put and various submissions made to the effect that, well, actually, this is all a relatively free environment because you could offer this or you could offer that. There are different options, and this is not mandatory. What that misses in my submission is the fact that if you have done certain things and you have arrived at certain conclusions, from that moment on, it does in fact become mandatory. The fact there are other options out there ceases to have any relevance. So it may well be true that at the beginning of your process, there you are, you know you've got to look into this, you've been told you've got to look into it. There's nothing you actually have to do save for look into it at that point. But once you have looked into it and you've arrived at the relevant conclusion, then you are indeed obliged to do what is stipulated in Dispatch 3. And that's what this quite correctly acknowledges. So second sentence of second paragraph, on this basis, a refund of just over £1,000 is now due to your client. And I do start to emphasise words like due now, taken with refund. I think the word refund actually characterises it rather well. Well, I'll come to develop that a little bit more in due course, but a refund is, in normal language, if you like, a unilateral act of giving somebody something back. And that, in my submission, is actually very important. So I go back to the point, there's no choice about making this offer, and any suggestion there is wholly mischaracterises it. And any suggestion there are no obligations here at this stage fails to appreciate what Dispatch 3 says and also fails to deal with what Skipton itself says here. Skipton is right here. And when my learned friend says, Mr. Wheeler says, well, Skipton were doing nothing more than was required by Dispatch 3. I'm with him 100%. That's exactly what they were doing. And that's what created the relevant obligations. But to say that's all they were doing, as in diminishing the significance of it, that of course is where I take issue. But that that's what they were doing is absolutely right. So you may recall I made some various points about choice right at the beginning of my submissions before. The point I want to make here is that choice is the subject matter of contracts. I choose to give you something and you give me something in return. And a question central to this case is if they've given us anything at all. And if they're obliged to do, and I don't want to jump forward to considerations, I am very keen to take this, but just to sort of flag that, if they're obliged to do what they're doing, then they haven't given consideration in my submission. So we see this characterisation characterised as a refund, and that's by Skipton themselves, and I would happily adopt that. They've worked out how much is due to the consumer by way of refund, and they've communicated that to the consumer. So the first point then is that there is an obligation to pay this money. Use the word in the broadest sense just for the moment, but I am going to refine it. There is an extant obligation to offer that money in the first place, and if accepted, pay it. Now, just focus on that for a moment, if I may. A lot has been made of the fact that this isn't an offer to pay. That, in my submission, is a mischaracterises what's really going on here, because it's one thing if the power not to pay is subject to steps that can be taken by the person who owes the obligation, that is one thing. But it makes no sense to talk about them not being obliged to make the payment ultimately, when the power to accept lies entirely with the other side. So there's no mitigation of that obligation. What they've undertaken is an obligation to offer, and if that offer is accepted, to pay. So they haven't retained any power there not to pay.
They have, because if the offer's not accepted,
That's not a
they don't have
power,
to pay.
but that's not their power, because all of that lies in the hands of the consumer, Mr. Harrop in this case.
There's no obligation though, if they make an offer and it's not accepted, they're not under an obligation to pay you anyway.
No, of course not. I accept that entirely.
And I understand the argument that by the time you commit yourself to DISP-Act 3, DISP-Act 3 gives a formula.
Yes.
But aren't you ignoring the fact that that formula is not mandatory, because you could offer, or you could be offered less, you could be offered more by way of redress. The references we were taking to yesterday, these are not exhaustive remedies. And so we come back to the plus or minus 10%. I think if I think you accept it, and at the moment I would be minded to think that if they offered you what we call DISP-Act 3 plus 10%, that is capable of giving rise to a settlement. But equally, DISP minus 10% would be capable of giving rise to a settlement. So I think on your argument, everything other than DISP-Act 3 itself is capable of giving rise to a settlement, and at that point, something's gone wonky.
Yes, I would agree. If that were my argument, something would have gone.
Well, I'm not saying it's your argument,
But
I'm
it's not,
suggesting it's
and-
something you've got to deal with.
I'm more than happy to deal with it, my lord. The position on the options to do other things, as I said a moment ago, yes, options exist in the first place, but once I have determined by carrying out the process that a given remedy is appropriate, a given redress is appropriate, those options fall away, because my obligation under 1.4.1 is to offer and, if accepted, pay redress of the appropriate or make appropriate redress. And that's how DISP meshes with 1.4.1. So that ability to take different routes, to find different ways to redress or different types of redress has fallen away. And Skipton itself, I mean, I do think this is important. Skipton itself are recognising this. They're saying required. They're saying a sum that is due. They're not using the language of choice. And they're right not to use the language of choice because they don't have any. So that's the starting point. Then my lord mentioned the fact that we'd had our DISP plus 10% discussion yesterday. But the way that works in my submission as a matter of analysis is this. 2 stages. First, Skipton has to satisfy its DISP obligations and make its DISP offer. That has no consequences as far as settlement is concerned, for the reasons I've said and will develop more. Your question, my lord, was could they, however, bring about a situation in which there was a settlement by offering 10% more? And I said in principle yes, but I think it works like this. Skipton goes to the consumer and says, I have these obligations, we have these obligations under DISP, and I'm going to offer you this pursuant to those obligations, and that's what I'm required to do, and you can accept it or not. In addition, and I do emphasise, I think all this would have to be very clearly set out so the consumer properly understood it. In addition, I am prepared to offer a sum, that might be 10%, it might be more, over that, and that would then make everything binding, and you'd have no further recourse to the courts or anything else. That would be logically possible, because in fact, the second part of that, the 10% bit, would be a distinct transaction. That would be a contract. You might wrap it in, maybe part of it, but the fact is it's quite distinct, because you've made clear to the consumer that the starting point is that there is no settlement effect, but I want a settlement, and that what you'd be doing at that point, I do think is very important, is you would clearly be moving from a regulatory obligation environment, I, Skipton, am required to do this, to a potentially contractual environment where you would be saying, I have done this, but in addition, I want, and note, this is an important matter of language perhaps, but I am now choosing to offer you something. And you can, just as you frame it that way, you can see the important distinction. I'm obliged to do this pursuant to regulation, but in addition to that, and I'll come back to the on top of, I do like that phrase from the authorities. I think it neatly encapsulates what we're concerned with as far as consideration is concerned. But on top of that, I'm going to make you a different type of offer. And that different type of offer is I'll actually pay you something that this isn't obliging me to pay you. But I want something in return, sorry.
You would say that that was something separate, entirely separate, because your disc payment was something that you were required to pay, and then you're saying, actually, separately, entirely separately,
Yes.
I offer you X pounds, which is an additional percentage.
Yes.
But you'd have to make clear, and you're saying, that those are two separate things, because you have your regulatory obligation and you have
Yes.
this additional icing.
That's
But
exactly.
it's not necessarily icing, it may be a completely different cake. And you'd have to make sure that there was a bridge between the 10%, the icing, and the cake, in order that it had any means of binding the amount you're required to pay, you say, under the regulation. Or otherwise, your icing is adrift from your cake.
Yeah, I think that would, my lady, just be a matter of contract at that point, properly a matter of contract, because the offer.
Can you do that? Can you therefore contractually bind the cake by the icing when the cake is, you say, a regulatory obligation?
No, I don't think I don't think you're actually, in many ways, affecting. I think it's the cake in the metaphor.
Yeah, the
Um,
regulatory cake.
I think what you're doing is you're identifying the cake. You're saying it's there, and we can deal with the cake. But the cake.
Is how it is.
Yeah, I can't follow this through because it doesn't
No,
work
the
on the icing.
regulatory amount is just how it is, and
Yeah,
we had to pay it.
You've got, can I just ask you this, which I think is a sort of variant on my lady's question. 3.8.4, never mind 3.8.3, which says the remedies are not exhausted.
Let me just pull that up if I may. Hold on.
Which is on page 959.
Thank you.
The firm should depart from the remedies set out in 3.7a if there are factors in a particular complaint that
Yes.
require a different amount
Yes.
or form of redress. That's contemplating, as I read it, that there may be particular factors which mean that you actually pay 65% rather than 50%.
Right, I think that
So
may well be right.
but you would still say that is an obligation imposed by DISP App 3. So if in the example we've been debating, I wanted to ensure that the thing was final and binding, I would have to offer another 10%, as it were, bunts on top of the 65% in order to get home, which seems to me to be very odd. But anyway.
Well, with respect, I'll try and answer both the sort of questions. It doesn't seem to me to be odd for this reason, that the two things are completely separate. And I know there's been an attempt at least to push the DISP into the 140A statutory remedy. But I think, although there is a relation, which I will come to, it's important to keep them separate. So it's important to think about it in this way. Here is a regulatory obligation imposed upon the parties for what I described yesterday, sort of systemic reasons. I'm a regulator, things have gone terribly wrong. I need to do something about the fact they've gone terribly wrong. Here is my broad brush response. It's not one size, it is one size fits all, etc. So that's what I'm going to do, and I'm going to require that. So Skipton now writes to its client and says, this is the thing I'm obliged to do, the very thing that it did do. And you can accept this money. But in addition to that, once you've accepted it, I'm now going to set out a contractual offer to you to pay you more. Of course, it need to be linked back because you'd need to carefully identify your consideration because you wouldn't want arguments like this. But you can well see what the consideration is because you're paying more than you're actually obliged to do by regulation. So conceptually and in principle, that doesn't seem to me to be hugely difficult. If the obligation arose not under 3.7 but under the later provisions, it's the same. Those are options, yes, I know that, but they become obligations when you say, I've gone through the process and I've determined that this is the appropriate thing. And that's when you, as it were, you come together with 1.4.1.
We're a long way from liquidated sums.
If I'm absolutely honest, I'm not particularly troubled by being a long way from liquidated sums, but I will come back to that, and I don't think we are that far. Indeed, actually, why should I come back to it? I can deal with it right now. They've gone through a process, a mandated process and a mandated calculation, and they have worked out what the refund is, and it's just over £1,000 here. That is a liquidated sum. We were a long way from a liquidated sum when we started. I'm not Skipton, so I probably shouldn't be saying we. Skipton were a long way from a liquidated sum when they started, but by the time they'd gone down to the process, they got to a liquidated sum. And my submission, my lord, there is simply no way around that. This isn't something I emphasise, something they chose. Indeed, let's be absolutely honest, they were dragged into this process kicking and screaming. The idea that they've actually chosen to make an offer just flies in the face of reality, but I don't need to trouble with that. The reality is that on the face of their own document, which properly does reflect what the relevant regulations say, they did something. And once they had done that thing and made a determination, a figure came out at the end, just like this, it comes out the end of a sausage machine. And that is a liquidated sum. Whether the language of debt and so on is appropriate or not appropriate, in my submission doesn't matter one iota, but it's an identifiable, use the word crystallised if you like, it's not a bad word in a sense because it started off being there in principle and then you went down the line and you got to it, but it's a fixed, identifiable, specific sum. And Folks and Beer will talk about, I'm staggered how often it's been mentioned so far, and what little part it plays in our case. We'll come to the real meaning of consideration in due course. But, so first step I say, is there an obligation? Yes, there is. And now I want to just characterise a little bit more about what that obligation actually looks like, what its effect is. And so the first real question is the obligation to pay a refund enforceable? My learned friend says not, until until acceptance, and that acceptance has a particular meaning. In his case, it's the acceptance effectively of a contractual offer. So we say the simple answer to the question is yes, it is, and that's by operation of Rule 1.4.1. And so when is it enforceable? And I submit that it's enforceable at any time from the moment that, in this case, Skipton identifies the amount of the refund. So if Skipton had done no more than tell you that it had gone through the process and arrived at the figure of the refund and hadn't actually gone on to say any more, and you'd written back and said, well, come on then, offer me my refund. Your letter tells me that there's one there and there's an amount, but you haven't offered it to me. Then, and Skipton refused to for whatever reason, then you'd have an obvious right of action in my submission under 1.4.1 for contravention. This is really important now. You'd have a right of action for contravention of DISP. Not because this was jolly unfair under 140A, but because there was a regulatory obligation to do certain things, and 1.4.1 is a rule that when there's a contravention, you have a right of action under 138D. That's what you'd have done. And you'd have said, probably sensibly at the same time, and by the way, I intend to accept that offer, so really my claim against you is for the payment. There couldn't be anything wrong with that, because all Skipton could do is come back and say, well, either I'm not going to offer, in which case still contravention, measure of loss must be what I would have got if you'd done what you said you should have done, namely offer it, and I would have accepted it, so you'd have had to pay it. Or they simply say, okay, well, yes, I know I've got to offer it, but I don't have to pay it, but you say, yes, you do, because I'm accepting it. So you'd have a right of action right there for the recovery of the amount of money. Of course, it's a right of action that only accrues if you're going to accept the money. I mean, there can't be anything in that, because you would never be claiming for a sum of money you didn't want to accept. That's just part and parcel of the process. Goes back to my point that the condition of an obligation to pay is one that lies in my hands. I'm the claimant. So that can't be some sort of diminution of the obligation that lies on Skipton.
But it's for damages under 138D.
Just going
So
to
it
confirm.
isn't just that individual amount. It may, although it pops up quite readily when you're looking at what the damage might be. For example, it also might be further delay and therefore further interest due, or further consequential loss as a result of not being paid when you should have been paid, etc., etc.
Yeah, but the point, my lady, is this: what we're looking at is their specific obligation to make this payment and whether it's enforceable. The fact that I could enforce more isn't the point. So this is, I'm saying, right up.
Yeah, but under 138D, you don't sue for a debt, nor do you sue for a particular amount.
You sue for the contravention.
You sue for the contravention.
Yes, and the contravention here is not paying the sum that was due and identified and accepted as being due by Skipton. That is the contravention. That's the contravention of the rules. That's what 1.4.1 gives me the right to do. And so it is a clear liquidated sum I would be claiming. If the section says it's a claim for damages, if this case turns on whether I've got a claim for a sum that is called damages, or I've got a claim for a sum that is called something else, then I'd be pretty surprised. The important thing is what we're concerned with, whether there's in the first place, a pre-existing obligation, answer yes. In the second place, although I say, for reasons I'll develop, it's not actually determinative, but I say nonetheless that is enforceable. And the fact that obligation, i.e. the obligation to pay, that's what 1.4.1 is there for. It's to say, in certain circumstances, enforceable obligations arise by way of action to court.
Okay, have I completely misunderstood the position? 141 is an R.
It is.
It's meant to be complied with. If you don't comply with it, then you have a remedy.
Yes.
App 3.7a, 3a is an E.
Correct.
So compliance with it tends to show that there has been compliance with the overriding obligation. But it's neither necessary nor sufficient on its own.
Well, I'm not sure about that part, my lord, but
Well, that's why I'm putting it.
yes. It may just be worth actually turning up 1.4.1.
957.
I'm sorry, was it?
957 is at 3.7a, 3a, 3e, 3a. What's worrying me, and what I think I'm not understanding about your submissions, which is why I'm raising it, is I have this sense that you're eliding the two provisions so as to make at 3.7a, 3a an R.
No, certainly not my intention, my lord.
Well, I think that's what you're doing, right?
Well, let's have a look.
Because you're saying that the obligation is to provide the at 3.7a payment, whereas that's not quite right, because as I've understood the position, because it's an E, the most you can say about it is that if you comply with it, then that tends to show compliance with the R
With the overall.
1.4.1.
So let's
So where have I gone wrong?
in the reading of 1.4.1, if I may say. So we go. It's actually at page 864.
Yep.
Yeah.
Once a complaint has been received, a respondent must do the various following things, and those things are in number 2, following the investigation, assess fairly, consistently and promptly the subject matter of the complaint, whether the complaint should be held, and then C, what remedial action or redress or both may be appropriate. Now what's happened is, relatively unusually because of the significance of the sort of post-plebeian claims, there is now a whole structure that sits underneath that for those particular claims. But what it's there to do is arrive at or impose further obligations upon the financial institution to take certain steps in determining what is appropriate. So once those have gone through, you're under the obligation, in my submission, in offer redress or remedial action where it decides this is appropriate. So what's happened is that the Building Society has decided that the remedial action is appropriate. There's no doubt about that. That's what they've said. We've complied with the regulations, and this is the consequence. So then you are brought directly, in my submission, within 1.4.1. So that if you don't then do what flows from that decision of appropriateness, you are in breach of 1.4.1. That's my position on that. I emphasise that, in fact, for reasons I will go into, but I don't want to here because it sort of steps out of the flow, there is no requirement for an obligation to be enforceable by action, in my submission, for it to achieve the end that I want it to achieve. But I just point out here as well, in the discussion between damages under 1.4.1, or sorry, under FSMA, and a liquidated sum and so on. Bear in mind, orally, I know various criticisms have been made of that, but it remains a decision of the Court of Appeal. We knew nothing in that case. The court didn't concern itself with what the nature of the action under the Dubai Ordinance would have been. It didn't inquire into whether that was a claim for a fixed sum or damages for some sort of statutory damages or any of that kind of thing. And the reason is because what it's looking at is the substance. The substance of the matter is an obligation to pay that amount of money. And therefore, if you don't do anything other than pay that amount of money, you've given no consideration. And I pause there to make this rather general point, because it seems to underlie some submissions from my own friends, but I might be wrong, that the mere payment of money itself doesn't transform something that doesn't have consideration into something that has consideration. It's not the mere fact of the payment of money, because that would undermine all of the cases in this area. Always you pay, and always the question is, have you paid with corresponding good consideration? Because you could always be open to a payer. So you've got a benefit. You've got a benefit. Otherwise, you might have had to sue me. But here's the cash. So I have provided consideration. Perfectly obvious that's not right. It has to be proper consideration moving from the promisee. Good consideration or valuable consideration in the eyes of the law. So yes, of course, payment will very often fulfil that function, but not for the mere fact of it being payment, but because it's the corresponding promise or performance. But just getting cash is, generally some sort of practical benefit, but it does not of itself, without more, without corresponding to consideration moving from the promisee, constitute consideration. Let's just catch up on my notes here for a second, if I may. So, existence of obligation, enforceability of obligation. So next step, what's the nature and scope of that obligation? I made the point already, my learned friend says Skipton doing nothing more than following the procedure laid down by DISP. We agree with that. So the central question, or at least a central question, is what does offer mean in this context? And I started out my submissions, I think, on Wednesday by saying there was real danger of a confusion and an elision and a movement from one meaning of it to another, and I would say that the last couple of days have definitely borne that out. If we're still in 1.4.1, if I may, so I think if we're going to look at the meaning of the word offer in this context, the right place to start is to see what offer means in the context of the obligation to make an offer. So that is, we're going back to 864, and we see that in little 3, still operating under the must, of course, the obligation is to offer redress or remedial action when it decides it's appropriate. Now, the use of the word there, offer redress, the expression offer redress, cannot sensibly be read as inviting Skipton to enter into contractual arrangements with its customer. It's a pure regulatory obligation to do something. And that something is offer the amount of redress arrived at by following the regulatory regime. That's what offer is. And then we follow that through to 5. Comply promptly with any offer of remedial action or redress accepted by the complainant. Now, if you just focused on that alone, in my submission, that would be an answer to almost all of this case. We know what the offer is. It's been identified a few lines higher up. We know that sensibly that cannot be referring to a contractual offer. And we are then told that it is an absolute obligation with a party to comply with that offer. Well, how do you comply with that offer? By unilaterally layering on conditions. You simply don't. You haven't complied with the offer. And you certainly haven't promptly with the offer or redress accepted by the complainant. There's no room in there for any layered on additional contractual provisions. And that doesn't conflict, my lord, with what we were discussing before about the possibility of the 10% arrangement. It merely means that that would have to sit outside this, and this would have to be complied with, if you like, as a prerequisite. And so, viewed that way, in my submission, it is perfectly obvious that the concept of acceptance here of an offer can be nothing other than an indication of a willingness to accept an offer that has been made by way of regulatory obligation. It doesn't import, it doesn't suggest, and it can't include, in my submission, any concept of a contractual offer and acceptance. Just looking at those words. There's no room for them in my submission. So, we're looking at the nature and scope of the obligation, staging post on the plain words of 1.4.1. It is blindingly obvious in my submission what the nature and scope of that obligation is. There's no room for ambiguity, and there's no room for introduction of matters other than that are there. But trying as I can to be helpful to Skipton and analyse what might be said, can the language of this, next question, be read as mandating or permitting conditions to be imposed on this offer? I mean, I feel at a certain point, I don't even need to address that because it just can't be the case in my submission there. But there is so much further one could say about that, against it, that some of it needs to be said. First point, nothing in the language, we've done that.
The logical consequence of your submission is you can never settle.
No, it's not.
You can never settle for the amount in dis at 3. The only way you can settle is by offering more than dis at 3, the 10% point.
Well,
because what you're saying is you can't bolt on saying, in effect, this is in full and final settlement of any.
no, you can't. I agree with that. That is my submission.
So you can't settle.
But I think your submission goes further, and I'd be grateful for assistance in relation, and it's still my cake and my icing, because I don't think the 10%, from what you just said, my lord, the Chancellor said you can never settle the cake, the regulatory part, but I can't see how therefore, and you said that the 10% is separate, and so the icing is divorced from the cake, and in that respect, how can offering 10% also ever bind back onto what you say is the cake? That was my problem before.
No, I understand the question. So perhaps
You're just offering 10%, and
well, perhaps I could
a bit foolish to do so.
Well, I'm not sure about that. Let's take it stage by stage. The first stage is they are mandated to offer this sum of money.
Yes.
So there is no reason why a party should settle for that sum and settle other things. There is no reason, it comes back to our case here, there's no consideration for that.
Yeah, your case is that stands alone and they're entitled to that.
Yes, so the
And
question.
they're obliged to pay, and that's the cake.
Yes, but so just to answer that, the first question first is, the answer to that, my lord, in my submission is that there is no reason for a consumer, and that would apply in almost any circumstance.
If we accept your argument, every Skipton and Santander letter, if they're still sending them from tomorrow, will be in identical terms, save that they'll say, and we're offering you for plus £5.
Well, then,
Or
it'd be a very interesting approach for a regulated entity to try and pull a stunt like that, if I can frame it that way, my lord.
it's not a stunt.
Well, it is a stunt because what you're doing is trying to induce a consumer.
More than you're already obliged to offer.
Yes, and in some areas of the law, that might well stand out.
£10, when does it stop?
As that-
10%?
That's the whole point, my lord. I don't know where it stops. That's a question of fairness of relationships and so on. But I do think we're getting into the slightly over hypothetical here. What I want to do is just take each of these questions because they've been bouncing about a bit, and I don't want to leave them unanswered.
And Mr. Mellon, I don't want to disturb your train of thought.
No, I want to answer your questions. That's my problem.
But in relation to that, therefore, in effect, you are saying that you can never settle because the regulatory cake is as it is. You can't put any gloss on it. And if you were to offer something additional, it would be a stunt which you shouldn't do. And I was concerned that also that because you have hermetically sealed the regulatory obligation, as you put it, nothing additional that you offer can refer back and become a way of settling that complaint, because you have hermetically sealed the regulatory obligation. And that's why you react the way you do to, oh, well, they'd offer £5, and then the question comes, oh, is there some sort of graph, and where do we stick on the graph about how much would be enough? But that's not really the question, because your answer revealed exactly, I think, and this may be right, but I just need to get to the bottom of it. But actually, the effect is that anything additional offered, it sails in its own boat. You cannot settle, is what you're saying. I think is the bottom line.
No.
The regulatory hermetically sealed amount.
I'm not. You don't have to settle the hermetically sealed amount because it's an admitted sum. The concern that's being expressed by the bench would be exactly the same if we were thinking about settling a sum that somebody comes along and admits. You say, well, you can never settle that. Well, you don't have to settle that because they admit it. But if you want to settle something beyond it, something more, then you need to offer more. There is nothing wrong in principle, so I'm suggesting, my lady, in offering a sum of money. It could just be a figure. It could be a calculation, 10%, but it could just be a number that says, here, you're entitled to that as of right. But I understand that doesn't represent the full scope of your claims arising out of these and related facts. We are anxious to settle all of those claims. And therefore, alongside this process, as a matter, if you like, of procedural convenience, the fact that we're dealing with you, we will offer you X at the same time in full and final settlement of that. But I think it's important to understand what we mean when we talk about settling the cake. If I'm right, the cake is an admitted sum. It's there, it's due, we can take it. We never have these discussions, we would never have these discussions in the more normal contractual circumstance where a party admits it. I wouldn't be, as it were, taken to task on, how do you settle this admitted amount? Because you don't need to settle an admitted amount. What you need to settle is the other stuff that surrounds it, or the amount above, if you like, the amount of the redress offer.
What do we mean by the other stuff, Mr. Mann? Are we talking about?
Well, that would depend on the facts.
Well, yeah, absolutely. But are we looking at, when you say other stuff, at other claims, misrepresentation, whatever, or are we talking about headroom above disk?
We could be talking about both, my lady. I mean, indeed, on our letter here, both are referred to. But actually, that's not strictly their case. incorporates both. But it could be headroom or other claims, because what you would be saying, what Skipton would be saying, would be there's this regulatory obligation to do this. That's all that's concerned with. But there are other matters out there. This may not be the full extent. You may say that's not the full extent of what you believe you're entitled to. That's the headroom. Or you may say you've got other claims arising out of similar matters. And we want to settle those. We've had enough of all this. At the same time as we deal with our regulated party hat on over here, we're doing what we're supposed to do, and we step over here and we say, yeah, but we're a commercial entity at the same time, and we're facing potential claims, and we would like to deal with them. But I think maybe at the heart of the difficulty, my lady, is that there is no real concept of settling the amount of money that is being offered through the DIS process. The settlement is the stuff that's beyond that. And I don't see, as a matter of principle, why there's a problem with settling those entirely separately, or in a sort of let's sort it out all linked together. But what they can't do, and if this really is the question, what you can't do is run into and infect that obligation, because that's there, it's clear, and it has to be done as a matter of compliance with regulation. But that doesn't mean
I just want to explore the as it were, the practical consequences of your submissions. Let's assume that we allow your appeal and your claim proceeds.
Yes.
Your claim and your particular claim is to be repaid, the whole lot, absolutely everything inside. And it said against you, amongst other things, well, you actually received some payments pursuant to the policy along the way.
Yeah, the rules say they're not to be deducted.
You have to give credit for those.
No, actually, you don't. The rules, I've got the reference here. You on a step 2 claim, you don't have to give credit for. I'll be corrected if I'm wrong, but
right. So okay. You say I'm entitled to the entire lot.
I mean, I'm told it would be. Sorry to interrupt, Rob, but just because I got that wrong. I'm told in the county court the sum would be deducted. So just to be absolutely clear.
Well, let's assume. Never mind that. It's just a gloss on them.
Yes.
But the logical consequence of your submissions is that at no stage, short of paying the full amount of the claim and going to trial for the full amount of the claim, could there ever be a settlement in this case?
I don't follow that. Well, that isn't my submission.
Because, well, it must be, mustn't it? Because let's say, for the sake of argument, you go on with your claim, and in 6 months' time, the Building Society offers you 75% as opposed to 50%.
But offers me a sum of
you
money.
couldn't accept to 75% because you're entitled to everything.
No, they're two separate things. So the Building Society would have had to pay me my sum of money, and then it would be done with its DISP obligation. It would have done that. But then I would have brought my claim, and or Mr. Harrop would bring his claim, and that would go through the courts in the normal way. The Skipton's obligations under DISP would have finished. Your Lordship shaking his head, and I don't. So
well,
I don't.
I'm shaking my head because I don't understand what your case therefore is about the 10%. Because if the 10%, which my lord put to you earlier on, which you seem to balk at,
No, I didn't.
and say that it would be some sort of colourable arrangement.
No, that was the £5, not the
£5.
10%.
Oh, maybe it was a bit stingy, call it £25.
Yeah.
But the point remains.
Yeah, my point remains, which is that if there is consideration given for the surrender of rights subsequent to settlement of regulatory obligation, then that falls to be considered on relatively normal principles, but always, of course, subject to the jurisdiction of the Consumer Credit Act. One can never ignore that in this environment. But otherwise, yes, it can be settled in principle, and I'm sorry if I haven't made my case clear, but
I think you have, and I think I don't want to go round and round in circles again, and I'm only saying this in order to, in case you want to have another go at it. But it does at the moment seem to me that you can on your argument, you can settle for anything, any sum other than DISBAT 3 sum. Because you could write saying we don't think you're entitled to dispatch 3 sum. We're going to offer you 25%. That would be, under the structure, it's permissible. And then I think you accept, once you get over dispatch 3, there's not a logistical problem settling.
Exactly. And that's the point. So any settlement process.
Then I think the consequence, you should know that at the moment, the way I see it, the consequence of your argument is that you can settle for everything except the dispatch 3 settlement sort of figure.
No, with respect, my lord, I don't think that is the consequence. And I think the problem with that is it elides the distinction between 2 different obligations. On the one hand, Skipton is a regulated party that is obliged, take my case on face value just for the moment, is obliged to pay a certain sum of money pursuant to its obligations. On the other hand, it is also a commercial party facing a number of other claims. It's not a question of settling for that sum of money at all. That sum of money simply has to be paid if accepted. Now there are other things to take into account, and you can settle those. So, with respect, my lord, I don't think it comes down to any question of you can't settle for any sum other than that. You don't settle, as I said to my lady earlier on, you don't settle an admitted sum. That sum is admitted. That's the very point of the consideration rule. You wouldn't settle that because there is no consideration for it. It's due, it's payable. But there it is, payable. Now what else am I going to do? And maybe I balked slightly at your lordship's suggestion of paying £5, but that's not the point. If proper consideration is given for a further promise to waive other claims, then that is a perfectly normal contractual process, which is acceptable, subject, of course, again, always to the jurisdiction of the Consumer Credit Act. Now, what I was going to say was, when we looked at whether you could import contractual intent into the word offer and so on, I'd already made the point that quite plainly on the face of the document you couldn't. And I was going on to say that on any view of the matter, DISP and 1.4 are detailed workings through of the respective obligations or the various obligations, I should say, of the regulated entity. There is no single mention of the possibility of saying, well, you can satisfy your obligations under this part by a contractual offer into which you can build conditions as you see fit. The one word that my learned friend relies on to suggest that may even be possible is the word consequences. Your lordships will recall that. The very reliance on a word with no content and no positive permissive effect, the mere reliance on that shows you to what extent this contract simply doesn't, or this regulatory structure doesn't contain such a power. And what would it look like if it did? It's really quite an extraordinary proposition that here you have a regulatory environment that's arisen out of bad things happening in the PPI market. So we're going to pin you down very carefully because we know that if we don't, bad things can happen. So that's what we're doing. But I tell you what, we'll make you do that certain thing, but just in case that feels a bit onerous, we'll let you fasten onto that conditions for your own benefit. Now, first, no language to that effect. Second, in that environment that I've just described, I would suggest it's plainly absurd. But third, where would it stop? What would be the limit of that condition? Some learned friends say, well, I'm just looking at this condition, that's reasonable. But there's no language that tells you that a condition has to have certain characteristics or others, because there is no language about conditions. So what would stop them imposing a condition that if you accept this, you'll get cash, and that's a rather good thing, so we're going to knock 25% off? Nothing. And yet that would obviously and self-evidently be wrong. What about imposing a condition that we settle not only this case, this claim for excessive commission, but also mis-selling claims and a whole variety of other claims? My learned friend can't really say that one's absurd, because that's exactly what they're saying has happened here. So what they'd be doing is translating by the imposition of a condition, the very condition actually that Skipton seeks to impose in this case, they'd be saying, I know we have a regulatory obligation to pay you this, but you're only going to get it if you waive these other claims. I mean, you've only got to say that. That just cannot be right. And if it's not right, which in my submission it really isn't, then there's no room for conditions. This, you just get to the point that that's a payment obligation. It's a systemic thing, as I said. It's designed, it's a product of the FCA's regulatory duty. And that would be against the whole spirit of the regime. And if you look at what that regime is, its purpose obviously is to arrive at appropriate redress. You can't be on the one hand obliged to calculate and offer redress and at the same time impose conditions on it. That really would be, I know there's been a few metaphors floating about, I've been a bit guilty on one or two occasions, but just to add one to the mix, that would be putting the fox in charge of the hen house. Because you'd really just be saying, yeah, here's all these obligations, but I'm going to denude them of any power by allowing you to impose conditions. And so that brings us to this question, which is underlying, I think, some of the exchanges. What is the relationship between the disk procedure and the underlying power of the court under Section 140A? So I think, look at a little background here. So, so undisclosed commission charged by financial institutions in excessive amounts led to pleving. Pleving was a decision under Section 140A of the Consumer Credit Act. There was an obvious regulatory consequence of that decision because the practice was so widespread. So once that had become apparent, you're a regulator in charge of this marketplace. What you're doing is regulating the levels of conduct of your regulated entities. You've got to do something. And the FCA was obliged, in effect, to impose rules, to create and enforce standards which previously had not been upheld, quite frankly. So the first step to redress that wrong at a systemic level, as much as possible, is by imposing certain obligations on those regulated entities, the very people who've been responsible for this problem in the first place. That's what you do as a regulator. You say, this conduct is wrong, something has to happen. Now, by its very nature, that step by the regulator takes no account of individual circumstances. It is, as the learned district judge said in his judgment, a one-size-fits-all procedure. That's not a criticism of it, it's a fact, because that's what they're doing. And, of course, it says nothing about what any individual claimant might achieve by his own specific claim under Section 140A, and or what view of the court may take, ultimately, of the correct tipping point. Because, so there we were, you'll recall that there was a very high rate, there was 79% or so in plevin. 71.8, Mr. Clark informs me. The judge said he wasn't going to specify what the tipping point is, but it was certainly way below that. Well, now imagine various cases coming to court afterwards, depending on what the levels of commission were, undisclosed commission, and the particular circumstances, the court would actually have to make very specific decisions in certain cases about what that tipping point was. That's not being decided, and it wasn't for the FCA to decide that. All the FCA chose to do, pursuant to its obligations, was come up with something that would redress the balance up to a certain point, at a systemic level, I would submit. Because what's happened is, a whole load of money has gone from consumers to financial institutions in circumstances where it should not have done. That's the effect of plevin. So what a regulator does, it takes a first step to redress that balance up to a point, and a whole load of money comes back from those financial institutions to the consumers as long as certain conditions are met. But in my submission, even expressing in that way says or shows how the idea of putting conditions on that relating to other claims that a claimant may have is totally contrary to the spirit of that endeavour. Because the reason action is being taken is because it's recognised that the wrong has happened, and therefore the wrong has to be remedied at some level, right at the outset. And that's what brings us actually rather conveniently back to the word refund, the very word that Skipton used. It's a refund. You get it back. It's not a refund in any meaningful sense of the word. If you say, well, you can have the £5.50 back for your shirt, as long as you don't, sue me for a whole bunch of other things. I mean, that's not a refund. And particularly not where the refund may have been offered pursuant to regulatory obligation to make a refund, which, of course, sale of goods environment often will do. Anyway,
I think it's actually called, yeah, no.
Beg your pardon, Mark?
Forget it.
okay. And my point here is this. I've spent a couple of minutes on regulatory purpose. What's the role of the FCA and what are they doing here to give context? Because I don't want to be here asking the court to do something on the plain, what I say are the plain words of the regulations that fly in the face of reality. In other circumstances, I might have to, because in the end, the words are what the words are. But here, the two things mesh. There's no question about it. They don't talk about contractual settlements. They talk about regulatory obligations and acceptance of the product of those regulatory obligations. And related to that, a very common theme of Learned Friends' submissions was that the DISP exercise was designed to settle a claim or a potential claim under Section 140A. That, in my submission, utterly mischaracterises what's going on and leads to all sorts of mistakes. He says that led to various consequences. The underlying claim was an unliquidated one because it was the 140A claim. There was no admission of liability by Skipton under Section 140A, he relied on. Correct. There was arguably whether it is or it isn't. To me, it doesn't matter whether there's an admission. There was clearly a dispute in respect of that claim, he says. So all sorts of consequences flow from the fact that you focus on the underlying claim under 140A. But that's not what DISP is doing. It's got nothing to do with that. We hadn't even made a claim. I don't think that really matters because no doubt some people had. In respect of the excess commission, I should say. So in my submission, an awful lot of what goes wrong here is because there's an attempt to characterise DISP as being some sort of quasi-contractual mechanism to settle underlying claims under Section 140A. And in my submission, it simply isn't that. DISP App 3 regime does what it says on the tin. It imposes a set of obligations on regulated parties. So what immediate consequences flow from that next stage? So you've got two things there. First, we've identified the obligations. Second, more than two things. We've gone to what the scope of those. Are they enforceable? What's the scope of them? And what intermediate effects do they have? And that's what I want to look at, those intermediate effects. The redress amount is a liquidated sum in the sense that it's a specific figure arrived at by a mandated process, no choice involved. That sum is acknowledged as being due by Skipton. They use the language of due. I'm not putting all the weight on that. I'm putting weight on the reality and the substance of the situation. It's not the amount that's due as a result of an admitted unfair relationship. That's not what's being admitted as due. What is admitted as due is the sum that I owe you under the regulated process. That's what's being admitted. And it follows from this that there was no dispute, because that's what they performed the mechanism, and that's what, there may be an underlying dispute elsewhere, but that's the whole point. That was not being settled. So, finally then, against that background, which I hope has cleared some of the ground, at least to clarify where we are on it, brings us to the question of consideration directly. Once you appreciate the nature and scope of the relevant obligations, the question of consideration or legally enforceable promise becomes, in my submission, actually quite straightforward. First, look at what consideration is in order to understand what constitutes such consideration and what does not. Now, I don't think we need to turn it up given the time, but you'll recall that we had a reference to Chitty at 625, which is at the front of the second supplementary bundle, and it made the broad point that consideration is something of value in the eyes of the law. And we all know the general principles about it needs to move from the promisee, that you can look to typically to detriment to the promisee. But I think the formulation in Ferguson and Davies encapsulates the point very effectively the general point. And again, I don't think we need to turn it up. I did take the court to it on Wednesday. It's at AB 87, page 324 of Ferguson and Davies. Top of the page A to B, and the observation made by the Court of Appeal there was that payment of an admitted sum, that was a particular subset, but that's not the point, was not giving the claimant any additional benefit on top of the admitted sum. And if you had to encapsulate the concept of consideration in one sort of short formulation, it would be that. Are you giving something over and above, on top of, what you were otherwise obliged to do? And that then, as we'll see, can obviously radiate out into different factual circumstances. But the critical thing is an additional benefit on top of what's already promised, admitted, and so on. So the analysis in each case has to be looked to see whether something on top has been provided. That's an analysis that would depend on the facts of each case. That's why you don't have to fit these cases neatly into Folkes and Beer or anywhere else. They're all based in the end on the proper analysis of the principle of consideration. And so the question is, was there consideration in this case? And in my submission, on the basis of the analysis of the relevant obligations, the clear and obvious answer is no. So the only way in which my learned friend addresses this fundamental issue is to keep returning to Folkes and Beer. We all know the old principle, part payment of undisputed debt is not good consideration, discharge of larger debt. And so ironically, it's simply repeating that on various grounds that we cannot bring ourselves within it. And here's the complete non sequitur. And so the argument of consideration, of no consideration, must fail. That's a non sequitur because what you've got is a general principle of consideration, and of course accordingly and correspondingly a general principle of no consideration, and you've got certain factual circumstances that sit under that, and one of them is undisputed debt, sort of Folkes and Beer type territory, admissions, no starting point dispute. All of that is fine, but what it doesn't address is the real question whether there is consideration in any given circumstance. So we say actually that the current position does come both within what I described as the broad principle and its narrow application in Folkes and Beer, in that there is a liquidated obligation, and Skipton is doing no more than offering to pay it, and once accepted, paying it, so that Skipton gives no consideration, and that's in paras 33 and 34 of our skeleton argument. But we don't have to bring ourselves within Folkes and Beer. What we have to do is show that there was no consideration for the promise. And we do that by saying that they've given nothing they weren't obliged to do. Absolutely critical. The payment of the money is not doing something they weren't obliged to do, because once we'd accepted it, they were obliged to do it.
And so I think follows from that you would accept that if the FCA hadn't intervened as it did after Plevin, let's say simply there had been no App 3.
Yes.
Skipton's offer would have been capable of giving rise to a bid binding settlement.
Well, what I would definitely accept is that an offer would, if framed correctly, be capable.
No, I'm asking about Skipton's offer. If Skipton had gone away without, if the FCA hadn't put in DISPAT 3,
yes,
and Skipton had gone away and done the calculation that they did and offered you the sum that they did in the terms that they did, that would have been capable of giving rise to a binding settlement.
Well, the only reason I hesitated slightly when you put it the first time, Lord, is that the way the offer is put is so bound up with DISP that it wouldn't really be possible to do that. That's why I qualified it slightly. But would it be possible in theory to settle the claim? I'm not perhaps the person best equipped to say what the circumstances under which a 140A claim can be properly settled, but I would agree that in principle, an offer that was offering to do something more than that party was obliged to do, Skipton, pay money over, but in particular if it was done in a way that was wholly compliant with the Consumer Credit Act, ought in principle to be capable of giving rise to a settlement. The critical distinction between the two scenarios being that in scenario 1, Skipton is not offering anything above what it's obliged to do, therefore there is no consideration. Scenario 2, it would be. But of course none of that jumps you out of the jurisdiction of the Consumer Credit Act. So I was just saying that it comes within the broad principle of Folks and Beer and that underlies Folks and Beer and its narrow application in Folks and Beer in that there is a liquidated obligation and they're doing no more than offering it. Sorry, I'd referred to 33 and 34 of Asplin there. So no consideration, putting it in normal traditional terms, flows from Skipton. There's no detriment to Skipton in paying that which it was already obliged to pay. And there's no benefit to Harrop, Mr. Harrop, in receiving that to which he was already entitled. And there's no point repeating that he did get a benefit because he got paid when he couldn't get paid before, because that was in his hands. Once it accepted, he always could get paid and he could always enforce that obligation. So that is really a poor distinction, one very heavily relied on but wrong. But we don't need, is the point, we don't need Folks and Beer. In some ways, the facts of our case are rather unusual in a purely contractual environment, because we say that in fact no contractual obligations at all arose. The point is, as I say, it works as a matter of principle on a number of grounds. You can look at it as a matter of admission, you can look at it as a matter of pre-existing legal obligation, you can look at it as a matter of no dispute, you can look at it even as a matter under the O'Reilly's example of the operation of the principle, that Skipton would have done what it did anyway. That's in a sense almost a sort of a derivative of the fact that it was obliged to, but you'd say that a regulated party would always ultimately do the right thing. You'd have to assume that anyway. And just think back to that point in O'Reilly. I know there's certain things been said about the case, but the way that the principle was so broadly framed, namely that if a party refrains from doing that which it wasn't going to do anyway, it doesn't provide consideration, is indicative, in my submission, of the nature of the inquiry you've got to go into. There's been far too much reliance on narrow differences in circumstances and not enough analysis of whether in fact consideration has been provided or not. So if you just give me one moment. Oh yes, just before me there was one thing that I had meant to mention. I think it was in relation to a query from the bench about why it is that, if I got the query right, that the Ombudsman's decision is determinative, and that is, got a note here somewhere, here it is, pursuant to FISMA section 228 subsection 5. So there's a statutory provision in the following terms: if the complainant notifies the Ombudsman that he accepts the determination, it's binding on the respondent and the complainant and final. And so it's via that very specific statutory provision that the binding nature of that determination comes about, following, of course, an adjudication. And I hope that explains that part of it. So, jurisdiction, I'll endeavour to take this pretty quickly if I may.
Yeah, I'm conscious, Mr. Manning, it's now 12:20, and
Yes,
we have to finish at 1 o'clock, and Mr. Butters is entitled to his time as well.
He is, and I appreciate that, my Lord. I will take it on the hoof if I may, just essentially identify the points. We say starting point is unfairness has to be assessed by reference to the whole of the relationship, including the credit agreement, the MPPI, and the compromise agreement, if found to be binding, which is the premise of this stage of the appeal. We reject completely the suggestion there's a two-stage process whereby you decide first whether there's been a bona fide settlement, such that if there was, you don't even get into the second stage of assessing fairness of the relationship as a whole. That was, I interpreted Mr. Wheeler to say yesterday. We submit that's just completely wrong, and talking about driving coach and horses, that would certainly drive the coach and horses through the unfairness regime of the Consumer Credit Act. We accept there are conflicting policy considerations, upholding compromise versus need to protect consumers, but we suggest that where the very environment in which the agreement has come into being is one concerned directly with consumer protection, and in which the consumer has been conspicuously let down in the previous related actions, that a good deal of force has to be given to the public policy as regards consumer protection. Now, I was asked by the bench on day one what it was that took this case out of the norm. Now, in my submission, and with the greatest of respect, that's not really the correct question. The question is simply whether the court can be satisfied at this stage of proceedings that there is not a case that could succeed a trial that the relationship remained unfair. And appropriate in this case, we say, as a part of the analysis, to look what the relationship looked like pre-settlement. That does not conflict with the Smith principle that you have to establish unfairness at the end of the relationship. The looking at the unfairness at the end of a relationship must necessarily, in my submission, take account of how you got to where you got. There's no conflict there at all. As part of that process, the court should consider the nature of the relief sought and the likely or possible outcome. Why should it do that? It might be asked, because we've moved on, haven't we? The reason is you've got to look first, in my submission, in determining fairness, to see what it is that the claimant has been asked to give up. It's important in assessing whether there's a fair process by which he gave that up. Just to take a very small example, if analysis showed that he'd only given up 5% of his claim, then you look very differently at the way in which he came to give that up. If, on the other hand, he gave up a huge percentage of his claim, more, you'd look with a great deal more caution. Once you've gone through that process, or as part of that process, it would be important in this case to recognise that Mr. Harrop had a claim for repayment of all premiums and compensatory interest. And that, just for your reference, we set that out at paragraph 42 of our skeleton argument. Yeah. Focus has been in this case, and I think this is quite an important point just to underline, the focus in this case has been on 50% as the threshold for the engagement of the DISP process. But what's not been talked about so much is the fact that that then is used, if you like, almost as a benchmark for the compensatory element. It's just everything above 50%. And you can see that in any given case, that might hugely undercompensate someone versus the full remedy of repayment of premiums and so on. Particularly if the amount over the threshold level of 50% of commission was quite low. So you'd be getting back very little compared. I've got some figures which I might share with you in a moment, just for a minute, but just to get an idea. But I can say, in the most general terms, that the distinction can be massive, like multiples of what this 50% settlement gave you. It would also, we say, include considerations of the profits still retained by the financial institution, even following the redress offer. That would entail consideration of the distribution costs. Why, you may ask? And the reason for that is that much of the unfairness of the original relationship arose out of the fact that the financial institutions, in effect, used its power and its position to profiteer at the expense of the consumers. No question about that. That's the obvious conclusion of Plevin. They weren't told about this massive amount of commission, 90-odd% in my learned friend's case. And so the banks made a huge amount of money. Well, when a regulator is trying to look at the system as a whole and then individual transactions, sorry, when the court is looking at individual transactions, forgive me, it's going to be very astute to recognise that the amount of profit left in the hands of the financial institution, even after redress, is an important element of the consideration. The court's not going to sit there and go, I don't care how much money this profiteering financial institution has retained even after redress. That doesn't matter. It's just irrelevant. And I submit very strongly that it can't just be irrelevant. So we say that the 50%, that is offer of return of commission over 50%, absent any justification by way of distribution costs, was intrinsically unfair. But if, contrary to that, a compromise was capable of being fair on that basis, it would have required a clear and transparent procedure to bring that about. As I said on day one, some of the features of that would have been, this is what we're obliged to offer the FCA, this is what, to offer by the FCA, this is what you're actually claiming, this is the benefit you'll be giving up, you won't be able to seek any other relief in respect of excess commission, we want to oblige you to waive any other claims arising out of these agreements, you should take legal advice and confirm to us that you have done so. Any attempt to settle would require those kinds of elements in my submission, and the higher the discrepancy between what was capable of being achieved and what was in fact achieved, the more necessary all that process would be, which is why you've got to go through that process. That certainly didn't happen here, and indeed, it's only after it would only be, if this argument obviously only comes into play if we're wrong, and we've had 3 days talking about whether these obligations did this or they did that or they did the other. That clearly didn't happen. We wouldn't be here if a fair letter had been sent. We'd know one way or the other. I'm not saying we'd have been liable in any sense at all, or hands tied, but we would have known. So we say the criteria in Hollyoake at para 504, which is AB 355, are not to be treated as rules or applied mechanistically as a test to be overcome, but I address them very quickly for completeness in any event. I don't know whether we need to turn them up, but I think the court has the principles in mind. It's 504 AB 355, where the judge goes through the criteria he has to look at as regards the compromise agreement. And I just want to touch very quickly on a couple of them. So the first one is, there's not a fair and arguable case. That would obviously impact on the fairness of any settlement. We say on Plevin, there was plainly a completely rock-solid case on unfairness. It was unanswerable. And there's been a point raised about whether the credit agreement with that is actually within section 140A. The question, and my learned friend said on a couple of occasions, well, we raised that would be there, and that would be another hurdle to be overcome. It's odd they haven't raised it, given it's a strikeout point, and this is effectively a strikeout application. And the reason it hasn't been raised is because the exemption under section 140A5, as enacted, was for land mortgages if entering into them was a regulated activity, and that only became a regulated activity on the 31st of October 2004, and our mortgage is 23rd of November 1990. So those provisions simply don't apply. And so far as that's on unfairness, on redress, remedy, no judge in the county court, and I'm speaking on instructions here, would have awarded as little as the excess commission over 50%. But we make this point in our skeleton argument. It's at paragraph 38, core bundle 42 to 43. Then one of the other requirements in Hollyoake is not fair and reasonable terms. That we say the sum paid does not reflect the nature of the relevant unfairness, being that Mr. Harrop purchased the MPPI without disclosure that there was a commission of the level thereof. And indeed, without disclosure in Mr. Harrop's particular case, that there was commission at all, which puts him into a somewhat different category of unfairness from the general run of cases, or certainly the Plevin position, where Mrs. Plevin did know commission had been charged, she just didn't know how much. Mr. Harrop didn't know there was commission at all. The example which Mr. Clark has worked, and I'll literally just give you the figures, it's taken from the table, January 2002, the redress given was 55p, the commission charged was £9.67, that was 52.97% of £18.25, the commission retained was £9.12p, that's the commission retained by the financial institution, costs including reasonable profits, assuming that 16% that we looked at, £2.92, therefore excess commission retained over and above reasonable profits of £6.20 and redress given 55p. So you can see just how dramatic these differences are capable of being. Obviously that accumulates over a long time. Last point, undue advantage, penultimate point, undue advantage. Mr. Harrop was an ordinary debtor whose occupation, we can see this from the bundle, was a sheet metal worker and engineer, that's CB32 and CB39, and those tasks, those functions didn't require financial sophistication. Skipton exploited its regulatory duty under DISP, imposed because of unfairness in the relationship in the first place, by imposing a condition of its onto its DISP obligation. Skipton failed to disclose its distribution costs, and or there was significantly less than the commission it would retain. So Mr. Harrop's decision to accept the conditional offer was not properly informed. And then finally, both sides advised by competent lawyers. That's the next level of test in or criterion. In Holyoke, Skipton did. Mr. Harrop had a claims management company. FRS didn't purport in its acceptance letters to have provided advice. FRS couldn't even identify the right statute. And we see that supplemental 1232, and by its acceptance letter purported to expand the width of the release given by its client, SB 254. My own friend said it was outrageous in a sense to suggest that a claims management company would do anything other than act for its own party. The point here is in investigating fairness, one has to recognise that beyond a certain point there is an inherent conflict, because the claims management company can't go to court. And that, in my submission, recognition of that and recognition there hasn't been any independent legal advice would be a necessary part of any unfairness analysis. I wonder if you'd just give me a moment. Yes, I'm reminded, I'm pretty sure the court is well aware, but under section 140B, the burden lies on Skipton, and quite proper to remind me that this is a summary judgment application. It's a summary judgment application, my lord. That's where we are. It's sometimes sort of easy to forget that, but that's the position we're in.
Thank you, sorry.
Thank you very much. Sorry.
My lords, my lady, my starting point is that, as we've seen throughout the course of the last 3 days, there are three regimes in operation here. There's Section 140A, primary legislation, there's DISP, delegated legislation, and then there's the common law of contract. Section 140A provides a right to an individual debtor to apply for an order under Section 140B on the basis of an unfair relationship. And that is a right to an assessment of the whole relationship, taking into account all relevant matters. See Smith, see Section 140A too. The defendant accepts that that right is not cut down by a compromise agreement. The relevant DISP rules obviously also have no effect on the claimant's right to invoke the court's jurisdiction under Section 140A. If Parliament wished the DISP rules to have that effect, it would have legislated to provide as such, and Parliament has not done so. And the right is not cut down even if the claimant goes to the Ombudsman and accepts a binding determination. And in my submission, that is the starting point for considering the issues in this claim. The amendments to DISP to introduce DISP Act 3 were clearly in response to Plevin, and it's clear from the policy paper that was much discussed yesterday that the FCA intended to create an efficient process to redress consumers post-Plevin, many of whom would have had unfair relationships as a consequence of undisclosed commission. And the response was to promulgate rules which set out hard-edge requirements imposed on regulated firms. And there are only two conditions required before the firm came under a duty to apply the rules mechanistically. First, the undisclosed commission had to be over 50%. And secondly, the claimant expresses dissatisfaction to the firm about the sale of PPI. Once the rules were in force, the initial aims of the Financial Conduct Authority are, in my submission, irrelevant. They were performing, the FCA, their regulated role, and they promulgated rules in order to fulfil that regulatory function. But it doesn't supplant the investigation the court has to undertake under Section 140A or the claimant's right to bring an action under Section 140A. And so there's no criticism on my part of the FCA for having reached the rules that they did. Those are the rules, and they operate entirely separately from the operation of Section 140A. But I say in this case, the DISP award does not remove the unfairness in the relationship. And I'd say that whether the DISP offer had been made without conditions, and I say that in this case where the defendant has purported to graft on conditions to the DISP offer. The consequence of the defendant's submission is that the claimant has a disincentive to accept the DISP offer to which she is entitled under the relevant rules in order to preserve her position in respect of Section 140A and any arguments that might follow from that. And the defendant is placed under the corresponding opposite incentive in order to restrict the claimant's rights under Section 140A. And in my submission, that cannot be right. The operation of the statute needs to be looked at separately, entirely separately, from the operation of the rules. And the rules clearly do not jurisdictionally fetter the claimant's access to Section 140A, but nor do they have an impact on how the court should undertake that assessment. Because in my submission, one doesn't start by building from the DISP figure and seeing if the claimant can get around it. One starts from the assessment of fairness demanded by Section 140A. And the relevance of the DISP rules and any DISP payment to an assessment of fairness is first, of course, it can be taken into account in the assessment of fairness. It is a fact that the court may consider to be relevant. But it is of no material weight in the assessment of fairness. The Court of Appeal in Harrison considered the
Sorry,
ICON.
Can you just repeat that? Relevance of the DISP rules and payment to the question of fairness is one, it can be taken into account.
Clearly, the fact of a DISP payment can be taken into account in the assessment of fairness, but it is not, in this case, and in any other case on similar facts, of any ultimate relevance for reasons I'll come on to under ground 3. The Court of Appeal in Harrison suggested that the ICOB rules were the touchstone of fairness for the purpose of Section 140A, and see how that was dealt with by the Supreme Court in Plevin. The same approach must be applied to these rules, whereas the ICOB rules said nothing. They did not prohibit non-disclosure of commission. They did not require commission disclosure. These rules come in, if you like, at the back end and are being prayed in aid on the basis that only commission above 50% is unfair, and any claimant that is left paying for commission at 50% necessarily has a fair relationship. And that is doing at the end of the process what the ICOB rules are unable to do per Plevin at the beginning of the process. The reality is what goes for ICOB, it goes for DISP. They're not the touchstone of fairness.
No, there's something you pray in aid because of the presumption it builds in a presumption that over 50% is unfair.
I praise and aid when I analyse the operation of the DISP rules, my lord. I don't praise and aid in support of the case on section 140A. Two regimes.
You retain the right to argue that less than 50% still gives rise to an unfair position.
Absolutely. So there's no sense in which the claimant prays in aid the DISP rules in support of her case under section 140A. So if we analyse how the claimant's case ought to be disposed of, and I addressed this obviously in my earlier submissions, there was no disclosure of the fact of commission in this case, and so in that sense it's distinct from Plevin. The claimant's evidence wasn't challenged, and her evidence was that she wouldn't have taken the PPI. That's credible evidence. See the various High Court observations in relation to that I've set out in my skeleton argument. But it's the defendant that creates the need to hypothesise as to what the claimant would do, what she might regard as a fair rate of commission, by virtue of its non-disclosure. And all the claimant can do is do her best to give evidence as to what she may have done or may have thought. But it's the claimant that's been deprived of the opportunity to evaluate the benefits of cover over the inflated price by virtue of the commission. And on any view, a benevolent approach to her evidence would have to be taken by the court in line with Keith and Isle of Man Steam Packet Company. And so in my submission, the defendant isn't in a position to describe the claimant as cynical because there was an oversight and she didn't cancel the PPI policy. The nature of the PPI policy here was that she may not have been paying for it at that time because it required an outstanding balance on the agreement. We don't have any detail in that regard. But on any view, the claimant did not decide to take the PPI policy on an informed basis. There's no evidence of any lower commission PPI policy available to her, and the defendant didn't seek to justify its commission at all, so it can be treated as 100% profit. So it'd clearly be wrong for the court to impose on the claimant in those circumstances a commission level that the court regards as tolerable to the claimant, or that the defendant submits is tolerable to the claimant, whether by reference to the DISP 50% principle or otherwise. And so I say District Judge Stone, in his judgment in Smith, was quite clearly correct in his approach to remedy. So this isn't the aspect of the judgment that was subject to appeal, and you've seen it's been praised by this court and the Supreme Court. I don't take that point any further than it is what it is, and clearly it's not binding. But I say if you read his approach from paragraph 53 onwards, you see what is a fairly classic way to resolve the issues at county court level, which is that DISP is one size fits all. He makes the finding that the claimant would not have taken the PPI policy had she known. He concludes the relationship is still unfair because of the continued non-disclosure of commission. And even if he hadn't found, because there was insufficient evidence, what the claimant would have done one way or another, he still would have awarded full repayment in the circumstances, because the purpose of section 140B is to remove the unfairness. And so that's the starting point. I start with the claimant's rights under section 140A to C and how that claim would ultimately have been resolved. And it then invites the question, well, how do you settle a section 140A to C claim, a point that clearly has been troubling the bench. let's put DISP to one side entirely and envisage a scenario that shortly before trial, in a case unencumbered by DISP, there's an offer to settle. Well, it's accepted that a compromise agreement is not a jurisdictional bar to an order under section 140B, and that a settlement agreement would ultimately form part of any subsequent inquiry into fairness. So clearly what would be required is a very comprehensive settlement agreement setting out the facts upon which the claim was based, the facts known to the parties, and clearly a section 140A to C claim was settled. Pausing there, and this goes to my ground too, none of that is present in this case. Now, if such a settlement was entered into, of course, there'd be no practical bar on a claimant bringing a further section 140A claim in the future. But then, of course, a compromise agreement in any field of litigation is not a practical bar.
It's not a jurisdictional bar.
One brings
It may mean that the court declines to exercise a jurisdiction it would otherwise have.
That's absolutely right. But even in a case where a compromise agreement is a jurisdictional bar, there's no practical restraint on a claimant issuing a further claim, and the court would have to resolve on an application for strikeout whether the compromise covers the subsequent claim. And although that would be an application on a procedural basis that the subsequent claim is an abusive process, the way in which the issue would be resolved would be much the same, except it would be a substantive strikeout application where you can't possibly succeed on your subsequent section 140A to C claim because, look, your claim is identical to the one set out in this very detailed compromise agreement. So in my submission, if the court wants an answer, that's probably the best way to go about seeking to settle a section 140A to C claim so that the minimum amount of fuss is encountered in the future if a duplicative claim is brought. Now, that's how it would operate absent DISP. When we then come to look at DISP, it is, as I've said, a self-contained statutory redress process. It's a regulatory redress process further to delegated legislation. And I absolutely adopt my learned friend for Harrop's submissions that when we look at the process, it is not importing a contractual analysis. There is a clear process at DISP 1.4.1 for offer and acceptance. I think it's agreed between all the parties that the function of that is internal to DISP itself, not least to identify those complaints that are resolved and those complaints that are unresolved. What the defendant has done here is, and I think I'm adopting the words of Lord Justice Stuart-Smith, graft on wording of waiver to what is otherwise a non-contractual offer further to that self-contained process. And my ground one of appeal focuses on consideration, and in one sense it's on the premise that therefore there would otherwise be a contract and a waiver that covers the claim, and my ground two focuses on whether the waiver covers the claim, necessarily on the premise that there is consideration. But actually, our position is that there's just not a contractual analysis to be brought to bear on this at all. Grounds one and two run together in that sense. And what my learned friend does is she focuses on the initial letter that the claimant wrote in March 2018. There's a dispute between us as to whether that's a letter of claim or a complaint letter for the purpose of DISP. You have my submissions on that. There's reference to section 140A. That should be read in light of DISP. But I have to say the reference to the word protocol doesn't necessarily suggest, in my submission, a pre-action protocol for a civil claim. There's an 8-week time limit for a respondent to respond under DISP. And what happened in this case, as in all these cases, is that once a DISP payment was received, if a further claim is to be brought, the claimant goes to a solicitor who writes a proper letter of claim for the purpose of the pre-action protocol, and that's what would have happened here. It's not like the claimant's relying on that March 2018 letter as the letter of claim. And it certainly isn't right that the claimant would have the option of ignoring DISP entirely and going straight to the small claims court. The only way a claimant could achieve that would be not to send the relevant letter, pre-action protocol letter, in the first place. These particular provisions of DISP, of course, at the time limit was August 2019, so it wouldn't happen now, but pre-August 2019, if you had a claimant that hadn't previously gone to a claims management company, went straight to a solicitor, and a solicitor writes a letter of claim to the effect that there's an intention to pursue a claim under section 140A to C, the response would be a DISP 3 offer. Because the letter of claim would be an expression of dissatisfaction.
Yeah. So in other words, writing the letter before action effectively triggers the DISP procedure within the financial institution.
Absolutely.
Assuming that they don't do the additional work and come to a different view.
Well, I'll come on to that in a moment, but it would certainly trigger, in practical terms, that's what happens. It will trigger.
The first thing they'll do is open DISP.
They will, and that's because they're under a regulatory duty to do so. And that's why I say lots of submissions yesterday were suggesting that the claimant has options, and of course the claimant has an option to reject the DISP 3 offer, but it's very difficult for a claimant to proceed in that environment without at least receiving a DISP 3 offer, and that's an offer to which the claimant is entitled under the regulatory process. In terms of what happened in our case, I very much, in my skeleton argument and oral submissions earlier, rely on DISP 1.4.1. I adopt my learned friend's submissions about the nature of DISP 3. I'm more than happy to succeed on that basis if those arguments find favour with the court. But really, I say one has to look at DISP 1.4.1. So page 864 in the authorities bundle. So once a complaint has been received, the respondent must investigate. We know the defendant has or ought to have done that, assess fairly consistently and promptly the subject matter, whether the complaint should be upheld, what remedial action or redress or both may be appropriate, and then 3, offer redress when it decides this is appropriate. You have my submission. The offer must match the redress that's been assessed as appropriate. So DISP 3 is the means by which the defendant in this case came to assess the appropriate remedial action or redress under paragraph 2C. Once the defendant has made that assessment under 2C, you can do away with DISP 3 because you've got to the point where the defendant is then under a duty under DISP 1.4.13 to offer that redress. So DISP 3 does nothing other than get you to that point. Subject to my learned friend's arguments, I'm just saying on this premise. Now, the learned friend says, well, this is a commercial case, look at the documents. I'm not suggesting the court shouldn't look at the documents, but this is a point where the court should and can look at the pleadings and witness evidence, because the question is, what was the defendant actually doing? And one looks at everything. And the pleaded case is clearly, as I've taken the court to, that the defendant was following DISP and calculated the redress further to DISP 3, and that's the evidence of the defendant. Now, DISP 3 is relevant there because DISP 3, as you know, is in terms that the defendant should pay. So if the defendant has assessed in line with DISP 3, then the redress that's been assessed as appropriate is a payment, unconditional payment, that is the offer they're obliged to make under 1.4.13. And that answers, in my submission, some of the questions posed during the course of my learned friend for Harrop's reply, because if the defendant had decided to offer different redress to dispatch 3, either more or less, once it had assessed that as the appropriate redress sum, then it would be under the duty, under paragraph 3, to make that offer. Now, of course, if the defendant offered less than dispatch 3 for no good reason, the claimant might be able to argue that there was a breach of 1.4.12c and not assessing the appropriate redress.
Yeah.
But the claimant would, notwithstanding the argument the claimant might have there, the claimant would have an entitlement to that sum under, or entitlement to an offer to that sum under paragraph 3. So when we talk about cakes, my lady, if the dispatch 3 is a standard cake, the defendant could decide to offer a value range cake or indeed a taste of difference range cake. But at the point the redress has been assessed as appropriate, whatever that is, you then look at dispatch 3. And so on any view, the defendant was under a duty to offer the redress sum. And I say the documents, the underlying documents are of a piece with that and are best explained by the defendant then grafting on a contractual waiver. But it's at that stage, it's within the statutory process. Now, learned friends made submissions on the payment can't be the consideration argument. But the next stage in our case is that the claimant signed the customer acceptance form and accepted the offer. Now I say that was an acceptance of an offer made under 1.4.3, and that therefore the claimant, having accepted that offer, is entitled to unconditional payment. The defendant is required to comply with the claimant's acceptance. And this court shouldn't allow the defendant to subvert the operation of the statutory scheme by holding that somehow, in using the waiver wording, the defendant has deprived the claimant the opportunity of accepting the offer that ultimately is the one that's been made following the assessment that the defendant has made as the appropriate redress. The alternative understanding as to what has happened is, I think, the position now advanced by my learned friend, which is that the defendant was indeed in breach of DISP in offering a devalued amount, not the redress sum unconditionally, which had been assessed as appropriate, but the redress sum plus a waiver, which devalued it, and that the claimant could and possibly should have pursued an action under 138D, but didn't, and that speaks for itself. With my submission, that analysis should be rejected, but it only goes to help me on ground 3. My lords, my lady, it was suggested by my learned friend for Skipton that the fact of entering into the contract itself was the consideration for the waiver, because then the claimant got the benefit of a contractual debt rather than a claim under section 138D. Just picking this up with the 10% example that's been given, if we imagine the offer under DISP 1.4.13, it's not a dispatch 3 offer at that stage, it's a DISP 1.4.13, whatever it is, whatever sum of money it is, and then a second letter at the same time saying, this is what we're offering you under the regulatory process. We'll offer you 10% more by way of contract if you accept a waiver. And subject to ensuring that the compromise is bona fide for other reasons, I absolutely accept that that would create a contract. I think what my learned friend is saying is you could have a second letter that offers 0% more, exactly the same sum, and it would be consideration simply because it gives the claimant a contractual entitlement to that money over an entitlement under statute. In circumstances where the claimant's entitlement under statute is for the very sum that the defendant has assessed as appropriate and that it is under a duty to offer and has offered, and in respect to which the claimant's action for a contravention of section 138D could only be for that sum. Any consequential losses arising out of that sum would be dealt with in interest in the same way that the contractual claim would deal with it. And so, my lords, my lady, that in my submission illustrates why there is no consideration. And then if we get to ground 3, the position becomes apparent because my learned friend has had to rely on a breach of DISP in order to establish that there is a contract and a defendant cannot use, in my submission, the statutory redress process, which is designed to protect consumers, in order to extract a waiver from the claimant that benefits the defendant to her detriment, where I ask, would that end, as my learned friend has alluded to? Unless I can assist you further, those are my submissions.
Thank you very much, Mr. Waters. Thank you all very much for your helpful and interesting arguments. Inevitably, we will reserve judgment. In due course, you'll get the draft judgment for any typographical errors to be pointed out to the court. Not an excuse for re-arguing points, so please resist that temptation. Please also pay attention to the terms of the embargo at the head of the judgment in terms of who has access to it and so forth. But as I say, thank you all very much indeed.
Court rise at table.